Well, hello, friends, and welcome to One Civil Law. And I hope you're having just the bestest of days possible. I want you to have the best day you can. And we are here today with Karen Reed. We are here to discuss some things that may or may not have transpired with respect to what was going on in last case. So we are trying to see exactly what AmpBev is upset about because at the moment it remains slightly unclear. When we last tuned in on Tuesday last, Aunt Bev was having a hearing relating to some things, and then the prosecutor made some statements that appeared to suggest, and it's a little unclear exactly what's going on, but appeared to suggest the defense had been less than forthcoming with respect to Arca in some way. Not exactly sure exactly what the nature of the problem is. It might be that she thought that Arca was being paid and the defense hadn't revealed it. It might be that she thought that there was underlying information that Arca relied on in rendering its reports that were not disclosed as part of discovery. It remains a little unclear exactly what she's upset about, but she says she has grave concerns. And so it seems like she might be teeing up the exclusion of Arca from being able to testify in the next trial. That seems to be like what we're teeing up, because she says, well, this has grave concerns for the defense. It's like, okay, yeah, what could that be? What would qualify as a grave concern? Well, it would be like excluding Arca would be one hell of a sanction, right? You somehow didn't follow the rules, and I'm going to sanction you by not allowing your witness to testify. So that's where we seem to potentially be going. But we'll see, of course, whether it goes that far, because that is, of course, a big deal. Also in the news, as I'm sure many of you are aware, the federal investigation appears to be at a close, at least according to two unnamed unnamed sources that we're talking to Boston 25, who have now reported that the federal investigation has come to a close. And that could be due to any number of reasons, not the least of which is, of course, because we have a new administration now. So I don't know who the U.S. attorney is in this jurisdiction at the moment, but that might have changed recently due to shifting things around. And so perhaps the new U.S. attorney is of a different mindset than the old U.S. attorney. So it could be that, or it could just be that the investigation came to its natural conclusion, and the U.S. attorney, as a natural feature of how they tend to operate, tend to be very conservative in bringing charges. So, the fact that the investigation seems to have come to a close without any action is not particularly unexpected, because the DOJ doesn't tend to like to bring charges unless they've got it, 5 different ways. So maybe they weren't able to satisfy themselves to the standard that they normally hold themselves to, because they tend to hold themselves to a fairly high standard, which is a good thing, probably all things being in balance. But this seems to be how it might have manifested itself. So yeah, and that is sort of what's happening there. And of course, we still have ongoing, in a parallel collateral proceeding, a federal suit on a writ of habeas to prevent this trial from going forward. The hearing for that is currently scheduled on the 5th. I don't believe the government has filed its response yet. As part of that, when they do file the response, of course, we will cover it as we try to decide whether or not there's anything there on the federal hook. As I sort of put in my pinned comment to the last video, after a closer look at that First Circuit case, it looks more promising for Karen Reed than I initially gave it credit for. So the language in the First Circuit case dealing with manifest necessity, namely whether the judge gave sufficient consideration to all available opportunities before declaring a mistrial, looks pretty good for Karen Reed. I think it's a very close match to the situation at hand. And sort of the two cases, like, these are pretty factually similar, and a lot of the factors look very similar to me. So I'm like, okay. So for the judge failing to consider all the possibilities so that there was no manifest necessity for the mistrial, I think Karen Reed looks now favored. Where she's struggling at the moment is actually on the issue of consent, because the case law is such that, you can't sit on an objection. And that, generally speaking, is true, right? In this context, this is not different than normal law. You can't sit on an objection. You have to make a contemporaneous objection, or you lose it, right? You use it or you lose it. So in the First Circuit case, the problem was that the lawyer was not given even any opportunity to object. Every time he tried to speak, the court just shut him up instantly, right? So he was actually not even allowed to object in that case. And that situation's a little not exactly the same as here, because this is in a situation in which they weren't allowed to object, arguably, although you could argue it the other way. They had 30 seconds or so while the jury was being brought back into the room to be formally dismissed. So sort of the operative legal question, or the most obvious operative legal question at the moment, is, although the judge said, I'm declaring a mistrial, was there nevertheless an opportunity to object during those 30 seconds? And assuming there was that sufficient opportunity to object? And assuming it was, then her failure to object would preclude her from using it. So basically, she consented to it by failing to object, or she waived the objection, if you prefer that understanding, but it's basically amounts to the same thing. So the consent issue is actually the most problematic issue. We've seen cases where basically the judge says mistrial and then just immediately storms off the bench. That didn't happen here. And we've seen cases where defense lawyers are sitting around for a couple minutes not doing anything. That's not really the case here. We're somewhere in between those two possibilities. So the consent issue is the hardest issue for Karen Reed. And given the posture of a habeas, in which it has to be clearly established, I still think on balance, she's likely to lose the issue. But of course, her odds have improved. So I give her now a 25% chance of success, because I think there's a more realistic possibility. The judge could obviously disagree with me on the idea that, like, for example, the moment she said, I'm declaring mistrial, the judge could theoretically say, well, then that's it. And that's like final at that point. And there was no opportunity to object. So if the judge reads the law that way, then she wins. If the judge doesn't read the law that way and says, okay, there was an opportunity to object, then it seems like 30 seconds might be sufficient. So especially on the habeas where things have to be clearly established. So I think 25% is probably right. It's something in that ballpark. It's hard to give a firm number on these things, because you're trying to, especially in the absence of any reply by the state, where they might have different authority or a different read of the authority. It's a little bit hard, but 25% seems it's better than where she was sitting before, right? Habeas relief is so hard. It's basically not going to happen. It's like, now at least she has a shot at it. So we'll see how the court looks at that situation. Should be interesting. And at the moment, we have OnlyFans with some hot action here, with some lighting as well. These two huge globes that are on screen right now. Two huge globes from this OnlyFans star. Exciting. Yeah. If she's convicted, there are appellate issues. Oh, there's always appellate issues, to be sure. Perhaps here more than most. But, appeals are for losers, as they say. And the judge gets a fair amount of discretion in how she runs her courtroom. So, judges get a lot of power. As I've said before, it's the sooner you recognize that a judge is a minor demigod, the happier you're going to be. It's like, the sooner you realize that the judge has that kind of power, you'll understand a lot more about what is going on. So, yeah, the judge is making a lot of rulings, many of those favoring the prosecution, but, you know, proving bias is incredibly difficult. You can't really prove bias just from the decisions alone. The case law is pretty clear on that. And so trying to find an abuse of discretion or clear error, and then, of course, in a way that matters is challenging. So, but that being said, for example, if she excludes Arca, that would fall into the category of like bigger decisions that are more likely to get the Court of Appeals attention.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves, starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Adam Lally for the Commonwealth. Good
Good
morning.
morning, Mr. Lally.
Mr. Lally's here?
Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan
I thought Mr. Lally was gone. We have more Lally?
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Who invited Lally back?
Good morning, Your Honor. David Dianetti for Karen Reed.
Good morning, Ms. Giannetti. Good morning, Ms. Reed. All right, so last week, upon hearing of a previously undisclosed relationship, perhaps, between defense counsel and the Arca witnesses, I took a recess here. We suspended. I had heard about email communication, detailed communication, memorializing a conversation regarding an engagement letter and a promise of retainer on March 20th and 22nd of last year, roughly 2 months before the Arca witnesses testified. There is another email that was 2 days before the trial and after the voir dire, 2 days before the trial with a list of cases. The Sunday before the witness testified, there's a proposed script of questions and answers and suggestions. And after the trial,
I'm waiting to be shocked, by the way.
an invoice or a bill, not just for reimbursement of travel and expenses, but for trial prep. Clearly, the Arca witnesses were expecting to get paid. So the Commonwealth, so I suspended for 3 reasons. The Commonwealth raised questions of candor with counsel in the court regarding the Rule 14 obligations. And frankly, I didn't think it was fair to have defense counsel stand up and have to answer to that without the opportunity to reflect, to talk to each other, to look at transcripts, to consult with people, and that it made sense to give you some time to do all of that, because what the Commonwealth raised does raise serious issues, not just the rights of counsel, but Ms. Reed's right to a fair trial and all that that entails. So it made sense to me to suspend first and foremost for that reason, so counsel can be prepared.
I'm doing this because I'm doing it as a favor to the defendant. We're in trouble, people.
What the Commonwealth told us is inconsistent with my memory. So I wanted to make sure that my memory was right. So in a way to do that, I went back and reviewed the transcripts again. I started with the June 10th transcript of the discussion with Ms. Giannetti, where I raised my skepticism about defense counsel in a murder case calling not 1, but potentially 3 witnesses that you never talked to. I looked back at the June 18th voir dire hearing, the June 24th trial testimony of the Arca witnesses, and the June 25th closing arguments of counsel. So after reviewing that, and my memory was pretty good about that, but what concerned me most is the memory that I had of a discussion here at Sidebar on February 6th, so 3 weeks ago, not last June, outside the hearing of everybody in this courtroom. And at the time, I was operating under the assumption that counsel was unable to provide the Rule 14 discovery because of a federal protective order. And the discussion at sidebar clearly revealed that, and counsel did nothing to disabuse me of that. So I asked the trial court to expedite a hearing, a transcript of that hearing. Mr. McDermott's going to mark it as evidence. And at that point, Mr. Jackson, when you didn't answer me at first, but when you did, you said, I can tell you this. The Commonwealth is saying, pursuant to Rule 14, and you know, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? So I don't have
Brace
any
yourselves,
more information.
people.
I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give Mr. Brennan. He's got the same information I got, and he got it at the same time. So that was concerning to me. Jim, do you have a copy of that there that you can? And I made sure. So the transcript is of the entire hearing because I don't want anyone to think anything's out of context. So
I don't think Ellen Jackson's gone. I think Arca's gone. I think that's where this is going.
I paused is because, frankly,
That's my
to
bet. I think Arca's
I
gone.
don't know what may flow from this. Obviously, I have to make findings, whatever they may be. But I wanted to explain why we recessed. I sent that one-page notification out last week about what we would be discussing. So I will hear from defense counsel if you want me to hear from you. If you don't want to say anything, that's fine too. But if you want to be heard, I will hear from defense counsel.
Your Honor, thank you for the opportunity to be heard. I am going to be responding on behalf of defense counsel to all of your concerns. I have a notebook that I've given, albeit just now, to Mr. Brennan. It's got exhibits, but it's everything that everybody's already had. It's similar to what you're doing, transcripts, documents, probative issues. And if, with Your Honor's permission, I'd like to provide you with the notebook so that you can follow.
That'd be great.
And should I hand it to someone here to have it handed to you, bring it up?
A court officer will take it for you.
Okay.
I appreciate that, Mr. Alessi.
You're welcome.
Thank you.
Here's another notebook to follow along.
Yeah, she's talking about Rule 14. She's talking about sanctions of excluding.
I'm going to go to the podium and make my presentation.
Okay. You know what? Actually, I'm going to take 5 minutes to just quickly go through this.
That would be excellent. Thank you, Your Honor.
Yeah. Yeah. So it's, yeah.
You are muted.
This is heading towards the exclusion of Arca is where this is heading. This is heading towards the exclusion of Arca. I told you that last stream. I'm telling you that this stream, that's where this is heading. If it's going to go this direction, this is not about excluding Jackson. This is about excluding Arca.
Good morning.
She said that she is concerned because she feels that Jackson was not candid to the tribunal with respect to representations relating to their potential hiring of Arca and including payments that were being made to Arca. And what she's saying at least is that she was blindsided by this, right? That she was not aware that there was this relationship. So there's nothing wrong with the relationship fundamentally, right? It's like when I was saying earlier in the stream, it's like I'm waiting to be surprised by what she's saying. It's like, okay, the fence is talking to Arca. They're coordinating. They're talking about things. There's even a script of questions they may ask and potential answers. So I'm like, yeah, tell me something I should care about, right? Tell me I should care something about. That just sounds like witness prep to me. That just sounds like perfectly routine witness prep. Here are some questions. Here's some potential answers. Let's work on it so we can figure out exactly the questions and figure out exactly how we want to answer it. Right? A lawyer can't counsel their witness to lie, right? And we can't coach, but we can prep. And that line can be interesting sometimes, but I didn't see anything that crossed the line for my taste. But I don't think that's the problem. I don't think the problem is the emails themselves. I think the problem, at least that the judge seems to be highlighting, is that she feels that there was a relationship here that was not made disclosed by the defense, because the defense has disclosure obligations under this Rule 14 to disclose these things, and that certain things were not disclosed relating to the relationship, including it looks like Arca was trying to get paid for work they had done when the judge seems to be under the impression that they weren't being paid by the defense. You know, that seems to be what she seems to be complaining about or upset about. So that the problem is the lack of candor to the tribunal, the lack of disclosure, the dishonesty, or the failure, even the failure of the attorney to correct the record, right? If the judge says something and that's not true, you know, you can't just sit there, you know, you have to correct the record. So, and it all seems like it's being teed up to exclude Arca. So that's the direction this is heading. I don't know if it's going to go that far, because that's a pretty big deal. That's a pretty big deal. That's, you know, something a judge can do. And to be honest, in some circumstances, at least something a judge should do, right? It's like F around and find out. Judges' orders don't mean anything unless there's an order behind them. But that being the case, of course, it's a fairly big deal. This is a criminal case. Excluding the expert witness that, you know, can provide this information is a fairly big deal, particularly this close to trial. So if she's going to do this, she needs to set up the record to show why this is an appropriate sanction, given the violation. And so that seems to be the direction we're heading. And so we'll see. Defense did lie to judge? Maybe. Yeah. Maybe they did. That seems to be what they're concerned about, but we're going to try to figure out exactly what's happening here.
They're right up there. They're right up there.
You are unmuted.
No, the other side too.
All right, so I apologize if that wasn't quite 5 minutes. I just wanted to see what it was that you had there.
Are you comfortable with what's in the notebook?
Yes, if I haven't read everything, but I know what each of them are.
Table of contents.
Yes.
Okay, good.
I mean, this gets down very much to who said what and when, and was it disclosed properly, right? All those things. You know, basically, was the rule followed? Was the rule followed, and did counsel fail to provide candor to the tribunal? Those are the two sort of questions that are present here.
May I proceed, Your Honor?
Sure.
Thank you. May it please the court. I understand the moment. The moment has categories and components. And in my presentation today, Your Honor, I am going to go through those categories in this order. I am going to start with the notebook that I handed to Your Honor and to Mr. Brennan this morning. The notebook is purposefully in chronological order. The notebook is in chronological order because I believe the best explication of the facts and what those facts mean come from a proper chronological presentation of the facts.
Makes sense to me. Timeline
I
matters.
also believe that the chronology is going to address many, if not all of the concerns as I understand from Your Honor. Your Honor, of course, will be the ultimate arbiter if they successfully address those concerns.
Yep. The judge
My
sure is.
intention, Your Honor,
Well.
is not to obfuscate, not to conflate issues. To the contrary, my intention is going to be to elucidate and to illuminate so that Your Honor can make the proper determination. That is my genuine goal for my presentation. As I go through, and I know I don't have to say this to Your Honor, you can feel free to interrupt, pressure test me on anything I'm going to say. I would welcome it, but I believe if I can get through.
Okay, if we could actually like get started anytime, that'd be
my hope
nice.
is that the facts will speak for themselves, but that brings
The
me
facts speak
to
for
my
themselves. You could just give them to us, just to say, by the way.
understanding the moment.
I'm not
which
sure
is
I need
going
this
to
much
be-
preface.
To also add to the fact is what happened at the last hearing, on February 18th. And I have the transcript for that, and I have that in the notebook, because I believe that is also critical to the proper elucidation of the facts.
So that's the only thing I have not previously seen.
The February 18th transcript.
Yes.
There are 9 pages that I'm going to go through, Your Honor, and because of the stakes here, I am going to go through it hopefully efficaciously and efficiently, but it's going to have to be methodically.
All right, so are you were addressing this in chronological order as well, right? So if you can tell me those pages now, I'll likely recess because I do want to see them before you talk about them, but I'll hear you going up to that point. So what pages?
How many
are those?
recesses are we going to do, man?
To the February 18th transcript.
I mean, I like recess as much as the next person, but you know.
Exact pages that I'm going to refer to, and Your Honor, get to the, this is tab 8
Right.
in the notebook. Mm-hmm. And
Yeah, it's totally fair, A.
specific
Hedinger.
pages that I'm
If the
going
judge
to
likes lots of
reference
prefaces,
start on
then you know what you do as a lawyer?
3.
You preface that
And
shit
those are
out all
9
day long, man.
pages
Right?
that
You definitely
proceed
want to tailor your style to the judge.
all the
So if
way
you're a
to
judge who likes long-winded prefaces, you give long-winded prefaces, man. Of course you do.
Substance ends
100%.
on page 62.
Okay,
And I appreciate that Your Honor wants to take a look at them because I think it's incredibly important for putting in context what happened at that last hearing. And I think it helps also do a compare and contrast to what the actual facts are and to what the statements were that were made on the 18th. So am I understanding, Your Honor, that you would like me to suspend
you
my
can,
brief or keep going?
no, you can keep
Okay.
going and we'll stop so I can read whatever I think I need to read
Sure.
at certain points, but we should be good to at least start.
Thank you.
And can I just ask, when was this put together?
Started about a day and a half ago and was completed this morning.
Okay.
I believe that.
All right.
Go right ahead, Mr. Lessie.
Thank you, Your Honor. So I start with tab 1, which is the March 22nd, or excuse me, go to the bottom, please, the March 20, 2024 email. And this is an email between Mr. Jackson and Mr. Wolf. It was sent from Mr. Jackson to Mr. Wolf. It was entitled Engagement. And so what I'm going to do is, that's where the notebook starts. But I want to go backwards to start in terms of something that is well known. And that is the federal investigation and the products of that federal investigation produced the Arca report. And that was in February of 2024. So what preceded this communication was a production of materials from the federal government, about 3,000 pages. Contained in that 3,000 pages was the Arca report of February of 2024. There was no index of the 3,000 pages, and the defense came upon that report. They got to reviewing the documents, in March of 2024. And as Your Honor will recall, the trial one started in April of 2024. So it was pretty close to when that trial started. And I know Your Honor knows from both your judicial experience and other experience that when you're entering into a trial of this significance, there's a lot going on. And so what happens is that report's produced in amongst 3,000 pages, it is located, it is read, the significance of it is immediately discerned. The report, basically the findings of the report that the vehicle, and this is important, Your Honor, because it really informs a lot of the emails. The substance of the report speaks to the issue of whether or not the motor vehicle of Ms. Reed made contact at all with the decedent, and whether the decedent's injuries at all reflect a contact with that report. Those findings in that report was set in cement in February of 2024. What do I mean set in cement? It means they were never changed, nor could they be changed. So that report was provided to the Commonwealth and to the defense. Next step, important also. Any party, the Commonwealth or defense, had access to Arca. They had the opportunity to contact Arca. There were restrictions that I'm going to get to on that contact. But either party had the opportunity to contact them. Now, only the Commonwealth knows why they didn't take that opportunity. It may be because of the findings. It may be for other reasons. I don't know. But I understand the facts to be that the Commonwealth didn't make contact with the Arca experts. The defense surely did. So that is the background, that is the information that we have. And so what happens? The defense sees the report, sees that the information in it is completely exculpatory to Ms. Reed. Of course, any attorney, lest they want to risk malpractice, is going to make a communication with that expert, which was perfectly legal and perfectly contemplated by the rules of the road, if you will. Now, as Your Honor also knows, the rules of the road with regard to the Arca expert were not set by this court. They were set by the U.S. Attorney's Office. And I'm importantly going to articulate with objective evidence what those rules of the road were. But the one key point is those rules were not set by this court. So the contact was made. This is one of the most unusual situations I've ever seen in my practice of law, meaning you have these experts, you have great exculpatory information, but there are significant constraints on how it is you can interact and utilize those experts in a complete unorthodox situation. Why do I emphasize that? I emphasize that because lawyers in trial practice are used to doing things a certain way. And when there are certain constraints that are imposed upon them, it becomes more sui generis, more ad hoc. And then there has to be sort of new ways of addressing the situation. That now brings me with that important background to tab 1. And to repeat, the communications start with a report from the Arca experts and their findings and their conclusions that never changed. They never changed.
Yep.
From the report they generated
something concrete. Got that part.
In tab 1. It may seem self-evident, but given the moment, I'm not going to take anything as self-evident. The defense had zero zero input into the report and therefore had zero input into the findings. And in fairness to the
Fair.
Commonwealth, nor did the Commonwealth.
Yep. So the report was generated completely independently of
With
both sides. Yep, that makes sense.
We come to the emails on tab 1. March 20, Mr. Jackson to Mr. Wolf. Please note that there is no CC to Mr. Yannetti. Why is that important? When we get to Massachusetts Professional Rule of Conduct 3.3A1, that fact is going to become extraordinarily important. So we have a communication, and it needs to be read in its entirety. Fortunately, it's short. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer, as required. I have the good fortune of dealing with experts probably every week. And this is classic form parlance. If it's going to be required, you always hope for your client that they're not going to require a retainer. But the language is as required, as. Also, if you could attach a copy of your, Dr. Rentschler's, and Mr. Klein's CV, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. At that particular point in time, there was no conclusion, no agreement, no knowledge that these folks would actually be testifying. There was certainly the hope, there was certainly the desire, but there was no agreement that they were going to be testifying. That was
Was the federal protective order that was referenced by Ms. Giannetti that said it was, and it was specifically outlined and ruled that they could not prep with us for trial. Was that in effect at the time these emails were sent?
The answer is, Your Honor, and I'm going to get to it, but I want to answer your question directly.
I'd like you to answer my question.
Yeah, I wanted to say, I'm going to answer it directly. What Mr. Yannetti articulated is the rule of the road, not prep, was not a rule of the road. That wasn't the rule of the road, and I have objective proof of that. The rule of the road was there would be no substantive conversations with the Arca experts, okay? That was it. But the answer to your question is I do not know whether the ground rules were in effect, but I can get you that answer, and I will get you that answer hopefully in moments during my presentation. But I do not know the answer.
All right, go ahead.
And it's an important question, and it's an important answer, I understand. But I'm going to give you information that's going to indirectly answer that question, but I'm going to get you a direct answer as well. So you see that there's an attempt to iron out the logistics for your preparation in the trial. Then we get to the email up above, and that is merely 2 days later. Again, Mr. Yannetti is not copied on the email, and my understanding is Mr. Yannetti is not knowledgeable about these communications.
Yeah.
So the email reads, "Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when we have it." Your Honor, this is not a direct answer to your question, but this is, to me, going to corroborate my point that if there was an agreement, and if they were going to be testifying, subject to whatever constraint, this email would not have been sent. There would not be a pause until we receive additional regarding our involvement moving forward. The involvement is clearly inchoate at that point. Why would Mr. Wolf be saying, until we receive additional information from their office, the U.S. Attorney, regarding our involvement. This is just talking about mere involvement. So what happens is, I call this the pause email, and it's regarding engagement. So Mr. Jackson on the 20th tried to get matters started. He's communicating to see if Arca's willing, if they're ready, if they're able, etc. And then we have the pause. The next tab is tab 2, which is the very important June 10, 2024 excerpt of the transcript. But the time in between, Your Honor, the March 22nd pause email and the 6/10/24 transcript is also exceedingly important. What happened between that? Well, to state the obvious, the trial had started. The trial started in April. Mr. Yannetti gave the opening argument for the trial. Do you recall, Your Honor, that Mr. Yannetti never mentioned the Arca experts in his opening?
I did not review the openings. I reviewed only, for the non-evidentiary transcripts I reviewed, was only Mr. Jackson's closing argument.
Certainly fair enough, Your Honor. Why do I underscore this point? Mr. Yannetti did not even mention the Arca experts because the defense didn't even know if they would be testifying. The two most powerful witnesses in support of the
I'm sorry, what was the date of the openings?
I do not know. I do not have it. It was in April. We can hopefully get there.
I can find it. I didn't know if you had it.
So, but clearly, Your Honor, it was between March 22nd and June 10th.
Right.
And so the most powerful exculpatory information from what we consider some of the most powerful witnesses were not mentioned because the defense didn't even know if they would be testifying. If there was an agreement that they would testify, that would have been in the opening.
Probably.
But the uncertainty about it is the reason why it wasn't in the opening.
Makes sense. You don't want to promise something you can't deliver. That's a bad idea.
What would be happening? So that pause continued through the opening. That to me is so key because I think it's antithetical to an agreement. Now we come to the June 10 transcript.
So he's basically saying there was no
As I
agreement
said, I am going to
at the
hit
time of the
head on
questions.
these areas.
Okay.
I start with, Your Honor, something that's not in the excerpts, but Your Honor may recall that there were a lot of Rule 14 discussions. And Your Honor and Mr. Brennan read this on February 18th at the hearing we just had, that Your Honor was making the point, which I appreciated, that with this very unorthodox situation, the defense was exclaiming, you were saying, I think you're in violation of Rule 14. They said, we've given everything we've got. We don't have anything more. Well, I know you can't, but you're still in violation. So Your Honor fashioned a remedy. Your Honor fashioned the remedy, the Rule 14 remedy, that there was going to be a voir dire, and that the Arca witnesses were going to have to come up from Pennsylvania, and they were going to need to sit for a voir dire. I will get to the significance of that, but that's what started, is the predicate for the discussion I'm now going to focus on. It starts on, this is tab 2, page 2812. Line 5, the court. Now, regarding the 3 experts from Arca, so I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided? You're referring to the defense, of course. Mr. Yannetti, Your Honor, we've provided everything that we know. We mentioned to this court at sidebar these experts did not arise from us finding them. The court, I understand that. Mr. Yannetti, these experts were hired by the federal government and they provided a report to us pursuant to the TUI request. And it was specifically outlined and ruled that they could not prep with us for trial. Court, and it's important not to stop there with what Mr. Yannetti said. There's more to that statement. There's an elaboration of it that is important. The court, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And I want to key into your words, Your Honor, because I want to be fair and precise. Your question—
That's exactly what I said.
Pardon me?
That's exactly what I said.
Yes, and I want to key in on you've never spoken, right, to and putting them on the stand. Now, no one ever said from the defense they never spoke to them, but that was what Your Honor was concluding from what was stated. So what did Mr. Yannetti do in elaborating on his answer? I didn't go back to the video to see if there was sometimes 2 people speak at the same time. I don't know. I'm going to assume it wasn't, and this was just a natural flow. So Mr. Yannetti says that's essentially it. But what follows is really probative. We've spoken to them only for the purposes of coordination of their testimony and their background. And I've got definitions of coordination and background that I won't provide, but those in Merriam-Webster's dictionary have specific meanings. But I don't have to parse that at this point. So I want to continue. We have not been—
If it comes down to Merriam-Webster's, guys, we're in trouble.
Regarding their findings, which are outlined in detail in the reports that both sides had. And I know the immediate response might be there, it might be at this point, wait a minute, you haven't had time to interview, et cetera, but what has been the communication up to that point? It's been the—
You don't like semantics arguments?
Mr. Jackson,
If you don't like semantics arguments, man, you are in the wrong field, man.
and then
You are in the wrong field if you don't like semantics. Holy shit.
That statement of Mr. Yannetti, as best as I can gather, is 100% accurate.
Yeah.
It is not,
Yeah.
it's not merely a response that stops with line 14 to 18. He goes on and explains exactly what the interaction had been up to that point. The statement of Mr. Yannetti is 100% accurate. Now we get to the court. See, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. We can't, Your Honor, and this was what I was pointing to before. So you can't, but you haven't. So I'm left with you haven't complied. So we need to get everybody here for—
What is the legal name for this hearing?
Well, we need to do that in
I mean,
advance
I'm not
because
sure anyone's ever called it this,
Your Honor. So the
but
defense
this is a
not
show
fighting
cause hearing.
with bringing them in for a voir dire. That's Mr. Yannetti said.
I'm not sure anyone ever used those words, but this is a show cause hearing.
I said I'm not going to conflate issues, but there's overlap of issues.
Yeah, that's what, at least that's what it's turned
Here we have a
into.
Rule 14 issue. Your Honor has concluded there's a violation. Your Honor has fashioned a remedy. The remedy is they're going to be subject to voir dire. The defense doesn't fight it. That is the Rule 14 remedy. But I'm going to get to how that interacts with the Model Code 3.3A1 in a moment. So we have then the voir dire. And what I'd like to, if I could, Your Honor, have you turn to tab 3, which is excerpts of the voir dire.
Page?
It's tab 3, and it's the June 18, 2024 voir dire examination of Dr. Wolf. And before I get to the specific parts of it, I know this is well known by Your Honor, but it's important to set the predicate for the elucidation of the points I am making. We all know voir dire is the opportunity for anybody to ask virtually any question they want of the witness to be voir dire. Your Honor set no limitations on the topics of voir dire at all. In recalling Your Honor's concerns, right, I don't know who even is opining on what. I went back and looked at that, Your Honor. Pretty fair comment, if I could, from the bench. It was hard to see. But please recall that wasn't the defense's making. We got what was sent in cement, the reports. That's the way they came. We didn't create a report that blended experts as to what they were going to say. That's what got dropped in our lap. So the voir dire was the opportunity for the Commonwealth to ask whatever questions they wanted to ask. There were no limitations. So up to this point, Your Honor, I'm going to use some words of others, because I'm going to come back to them after we talk about the February 18th hearing. There was no compensation as of June 18th. There was no promise. There was no reward. There was no inducement, unless one tries to define inducement as being the hope that you'll get to have these experts testify on behalf of the defense. There was no favoritism, because the Commonwealth had the opportunity to interact with the Arca experts. They had the opportunity to call them as witnesses. And we sure know that the Commonwealth knows how to conduct a rigorous voir dire. Please simply recall Attorney Brennan's voir dire of Dr. Russell. That was the opportunity. They had a Dr. Russell opportunity with Dr. Wolf. What they chose to do with that opportunity, of course, is fully the discretion of the Commonwealth. The Commonwealth did not ask numerous questions that someone with the benefit of my hindsight in Monday morning quarterbacking would have asked them. But I would have asked them a lot of questions, especially given the unorthodox situation and given that the defense quickly jumped on the opportunity, right, to interact and call these witnesses. But they didn't take advantage of that opportunity in the voir dire. They didn't ask those questions. Had they asked those questions, they would have gotten answers. Now, Your Honor, I don't say that that in and of itself addresses the Rule 14 issues. I'm going to get to those. But I want to get to the prejudice, and I want to get to some of the other important issues. I'm going to highlight, because I'm going to come back to it, Your Honor, page 1-67. We heard at the February 18 hearing, and again, I'm going to come back to it when we go line by line for those 9 pages. Not line by line, but many lines. If I could draw your attention, please, to line 12. It starts with line 10 to put it in context. What about human factors? This is the voir dire, direct voir dire. So Mr. Jackson is asking Mr. Wolf the questions. What about human factors? What does that discipline entail? What is human factors? Answer. Well, to give you an example of that, so I do a lot of nighttime visibility work. And then it goes on where, for instance, let's say a pedestrian is coming down to the roadway at night. There's also going to be, that I'm going to get to in chronological order, Dr. Wolf on direct, talking about nighttime visibility work, etc. But if Your Honor could just please note the absolute raising of the issue of nighttime visibility and pedestrians affirmatively in voir dire. So that was voir dire, no restrictions, opportunity to ask whatever they wanted to ask, and as a highlight, the voir dire brings out nighttime visibility work. If Your Honor could please turn to tab 4. Tab 4 is the June 22nd, 2024 email, but it's important who it's from and who it's to and who's not on. From Daniel Wolf to Alan Jackson, subject Wolf qualifications. No David Yannetti on this email. And Your Honor, because I've said it so many times, Mr. Yannetti not being on the email, I can tell you from my own experience in this second trial, but this was, I understand, the first, there was a division of labor. There was a lot going on. This is now June. This is in the middle of trial. Everybody's got responsibility for their witnesses. So there's not collaboration going on. It's not the luxury I usually have at my law firm, where you're sitting in a nice big conference room and all the attorneys are sitting around the table all the time, let's say in March, etc. But clearly in June, the trial's going on. But they're dealing with their own witnesses at that particular time. So let's read it because it's short, but it's important. I'll repeat again. This was an email from Daniel Wolf to Alan Jackson. Alan, I spent this time this morning putting together a brief outline of my qualifications. I've also attached my D&T deposition in trial, in the trial parlance. I know it's nothing compared to Andy. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. I will try to work on some direct examination questions tonight. So I want to start with, without getting tech geeky about it, some basics, because these basics were not brought up and I believe led to confusion on February 18th. If you look at the attachments, every email, as we know, has a lot of information on its face, and one of it is you can always tell what goes along with the email. So this is attachment Wolf Qual's document. But what's the most important points, I think, to be gleaned from this objectively, Your Honor? Mr. Wolf prepared the document, not Mr. Jackson.
No, I'm well aware of that.
Okay, so he prepares it, he sends it along to Mr. Jackson, and it's on qualifications. The next is, if you would just please turn to the attachment, which are the qualifications, etc. There's a comment, and these pages aren't numbered, but the questions are. If you look at 19, nighttime visibility work. And there was a comment, and this was referenced on the 18th, but I'm going to come back to this. If you don't want me to say that, that's fine. That very testimony in that very point was elicited by Mr. Jackson on the direct that we're going to get to. There was no hiding of it.
I read that as well.
Good. Thank you, Your Honor. The next tab, and of course, it has the D&T of Dr. Wolf, his experience in testifying in court, et cetera, et cetera. I will indicate, Your Honor, that the information in terms of quals, et cetera, all of that to me, would be basic questioning in a voir dire. But those questions, to the best of my knowledge, were not an issue of concern for the Commonwealth with regard to voir dire. I mean, but again, that's what voir dire provides the opportunity for. So next we have tab 5. June 23rd is Sunday at 2:59 p.m. from Daniel Wolf to Alan Jackson. Subject Wolf Direct, attachments, Wolf Direct. So it's clear, and then if you turn the page, that is the attachment, is something that has no labeling on it, but I don't think anybody is going to misunderstand that this is what's being referred to in the attachment Wolf Direct. So all the topics that are in this direct were all in the report of Arca, the frozen in concrete report of Arca. And we will get to this, but what I did was I went and compared this outline.
I did too.
Your Honor, there's one thing I've learned in the short time I've had in this courtroom, is that Your Honor is on everything. And the reason
Never hurts to suck up to the boss.
This is because it's going to come to an application of all the legal principles. So I very much...
Your Honor is the
genuinely very much
bestest honor.
appreciate that Your Honor
Just
has,
the bestest,
you know,
most prepared honor. Your Honor's the
exactly
bestest.
not gone through and looked at all of
Never
this.
hurts to suck up to the boss.
So all of this is what's in the report that everybody already has. Why do I make that point? Because the rule 3.3A1, it has relevance, but it's got more relevance to the rule 14, and we heard on the 18 a very long buildup in an emphasis on the Commonwealth not having access to information, being surprised, et cetera, et cetera. So the point here is, additionally, if you compare...
Does he have the shiniest apple? I tell you what, my friends, if I were a lawyer and I thought the shiniest apple would win my case, I would come in with an apple so shiny it would blind you.
I make that point because of two things. First, Mr. Jackson did not prepare this document. One of your questions at the February 18 hearing was, what's the day, et cetera, and I'm going to get to it, and I'm going to use words, not characterizations. That's why I don't want to go into it too much here. But there was a certain impression made about who had prepared this document. But I want to underscore it was Dr. Wolf who prepared it and sent it to Mr. Jackson. Now I want to get to the timing.
I'd also
because I
have
think it's
several
very
backup
important.
apples just in case the apple I brought isn't your favorite varietal of apple.
This is Sunday, June 23rd.
I'd have options.
2:59 p.m. The trial resumed the next day, which is going to segue me eventually to tab 6. And if Your Honor would look at the first page on tab 6, it's June 24th.
Sign you up for an apple of the month club, damn.
2024. The very next day, probably less than 24 hours after this outline goes to Mr. Jackson, Dr. Wolf is on the stand. If anybody thinks that Mr. Jackson was waiting for an outline from Dr. Wolf to be able to prepare one of the most important direct examinations of the trial until he got it, I think that person would have to have quite a fanciful imagination.
I don't think there's anybody here who thinks that.
Thank you. So the other important point to underscore is that this was something provided by Dr. Wolf, not drafted one word by Mr. Jackson. So if someone is to say that, and I'm not inferring Your Honor, but someone else might want to infer to say that this is a blatant Rule 14 violation, this should have been turned over, et cetera, et cetera. What happened the next day, 1 day later, that would have required Mr. Jackson in the middle of trial with an unorthodox situation, trying to figure out what to ask Dr. Wolf, under what parameters, under what constraints, et cetera, that he should have also had the thought, oh boy, I got this in at 2:59 p.m. on a Sunday. I better hurry up and communicate with the Commonwealth and go provide that to him so I comply with Rule 14. I'd like to believe that I'm very diligent about my Rule 14 obligations, Your Honor. I'd like to believe I would have done it. I don't believe I would have even thought of it, came to my mind. We know what the standard is, but I want to underscore the connection in time between Mr. Jackson gets this and when Dr. Wolf is on the stand, because that's really the prejudice time period or potential, if you will, that occurred. Not even to bring in the voir dire, that this could have been brought up, all these topics in the voir dire. Not that voir dire satisfies all Rule 14 obligations, but the reason I brought up Your Honor's Rule 14 remedy was it was the remedy, I think perfectly tailored to the situation, to basically say, I don't, as the court, understand, these folks haven't gotten what the court found was their proper discovery. We're saying we don't have, the information to turn over in terms of it. We got the report, and all we had is emails in March, right, that are, in my view, non-substantive. They're communications. They're Rule 14 material, no doubt, Your Honor. But the question is, what's the prejudice from not getting those emails in light of the voir dire that Your Honor ordered? We'll get to those under 3.3A1, but under Rule 14, they clearly are of no prejudice to the Commonwealth. So now we have the trial testimony of Dr. Wolf. I mentioned, Your Honor, about the nighttime visibility issue, because much was made of that in the hearing 1 week ago. If Your Honor could please turn to page 3665, starting at line 22 at the bottom. Question. Mr. Jackson, this is direct. Mr. Jackson is eliciting this testimony. Remember the comment, I don't know if you want to bring this up? Mr. Jackson now is eliciting this topic. And how many of those 1,000, I know you don't have a number specifically, but how many of those 1,000 would you say involve pedestrians as well? Answer, several hundred. As I mentioned earlier, you know a great deal of my work is in the field of lighting and visibility, so there is a direct correlation between time of day and pedestrian incidents.
One would imagine.
Key sentence. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. Elicited, discussed. Now to some very important communications.
Yeah.
On direct. If I could ask Your Honor to turn to 3669.
Yeah, I'm so glad I had an expert to tell me
This is
that pedestrian collisions are more likely at night when it's harder to see. I'm so glad there was an expert to tell me that.
Your expert review.
There's
Dr.
no way I would have known that in the absence of an expert.
You and I had never met. Answer, that's correct.
Wow.
100% true. You did not know who I was. I did not. 100% correct. You had never met Miss Little? No. That's correct. Mr. Yannetti? No. Fact. As a matter of fact, you had never heard of this case. That's correct. Page 3670. Line 10. Question. When did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct? Answer correct. Question. And that report is contained in a multi-page document that was
Yeah, the prosecution's arguing over it. I know that. The prosecution's arguing over it. I still think it's dumb.
So
I don't mind him mentioning it. It's just like, it's still funny to me.
You had never met us. Didn't know
But
who we
I
were
understand he
when
should have
we did
mentioned
this.
it. He didn't do anything wrong by mentioning it.
Now, if you could continue on, Your Honor, to, I believe, if I could be so officious and say, this may be some of the most key aspects of the testimony for Your Honor's inquiry. 6, question. All right, it goes without saying, I'm going to ask it anyway. You haven't been paid by the defense. Answer, you have not paid us anything. No. 100% correct. And you don't work for us. That's correct. There was no engagement. There was no engagement letter signed. There was no retainer.
Okay, I
Those
like that answer.
discussions that were started on March 20th.
I like that answer. At the time the question was asked, there was no engagement letter yet.
And they never,
So there was no lie. I like that answer a lot.
they were never re-engaged. They got to eventually get them on the stand, but there was no retainer. There was no terms of the engagement. To the best of my knowledge and my review of all these facts and discussions with counsel. So then the next, that's correct. Question. As a matter of fact, I've never asked you specific questions about your testing before today. That's correct. Mr. Wolf sent
No
in
substantive discussions. No substantive discussions.
Mr. Jackson asked.
Yeah.
But that's why I underscored so many times the fact it came from Dr. Wolf to Mr. Jackson. It's not Mr. Jackson asking questions in that document. It's Dr. Wolf sending them in. And, Your Honor, I'm going to speculate if I could, and I'm not going to do this often in my presentation. But I do know a fact, and I do know, and a fact I know secondhand. If we put ourselves in Dr. Wolf's position, we think it's odd for attorneys. Imagine him. He's about to sit on the stand in one of the most visible cases in the country. He is an experienced expert. He's used to interacting with attorneys. He is not having the level of interaction and preparation anywhere near what he's used to having. But he's got to go on the stand with his professional reputation, and he's nervous. He's nervous. So my speculation, he sends in the direct to try to get some degree of comfort.
So with all due respect, please don't speculate. Let's move on to the merits, okay?
I will not.
You can use this maybe at argument at some point, but let's just focus on what we have.
I will do that, Your Honor. And I said
If you know for certain that's the case, that's fine.
I will tell you, and first of all, I appreciate what you said, and I won't speculate anymore. I said I was going to make an exception for this, but here's the fact that I do.
No more, because you said you might do it more than once. So no more speculating. But if you know for a fact that that's true, I'll hear it.
Your Honor, first of all, completely understood, no more speculation. There will be no more speculation until we get to February 18th. I think it's really important.
Okay.
Because the Commonwealth on the 18th speculated a lot. And I think the only way to fairly...
So let's go back to this, okay? You'll get to February 18th. Do you know for certain that that's what Dr. Wolf was thinking?
Here, I will tell you the basis of it, in fact. I've spoken with Mr. Jackson, and Mr. Jackson said that Dr. Wolf was anxious about the fact that he had to get on the stand without having the typical level of preparation and knowing. That is Mr. Jackson's sense of Dr. Wolf's situation at the time the direct was sent. So, can I say for certain? No. Can even Mr. Jackson say for certain? No. That's the sense, though, that was extant at that particular time.
Okay.
So we then go down to the next question. But I want to.
She seems pretty hostile to the defense, guys.
I've never asked you specific questions.
I like his answers. I think his answers are perfectly reasonable. But the judge does not seem to agree with me.
The report that you provided was provided both to the defense as well as the Commonwealth. Is that right? That's my understanding, yes. And you were equally available to both sides in terms of them reaching out, correct? Yes, and I called you ultimately after receiving your report and asked if you join us and testify, correct? That's correct. Why do I point that out? Because it's not only my sense when I said earlier that and I don't think this is disputed, the Commonwealth had equal opportunity to.
What do you guys think the over/under on Arca being excluded is right now?
So
Why don't you put in chat what you think the percentage chance is that Arca is excluded as an expert? Is it 10%? Is it 30%? How likely do you think it is? Put it in chat.
Dr. Wolf, and I want to just speak to the findings because on page 3676 to 3677, because the findings never changed one iota from the report Arca issued in February to Dr. Wolf's testimony. There's been a lot of talk about potential cause and effect of the interaction Mr. Jackson had with Dr. Wolf before he testified. And the key emphasis, and I think should be the key concern of everyone, certainly was the concern of the U.S. Attorney's Office in the federal investigation. They didn't want those findings altered in any way. And the U.S. Attorney's Office basically said, we don't want any more additional testing. We don't want anything. You're going to get these findings, and you're going to deal with the findings that they have. So what were those findings? Bottom of 3676, line 25, did you perform an accident reconstruction? Specifically focused on determining whether or not damage to the Lexus was consistent with hitting Mr. O'Keefe. Answer, yes, I think that's a fair characterization. And reversing that was your accident reconstruction also focused on whether or not the injuries to Mr. O'Keefe were the result of being hit by a vehicle. So it's important to know in terms of, whatever the interactions were and whatever the effect of the interactions were, is that the findings always stayed the same. And what was elucidated at trial, what was presented to your court, was not anything whatsoever different from what was established in cement in that report in February of 2024. So now we go to, and of course, the findings of Arca being that the vehicle did not come into, Ms. Reed's SUV did not come in contact with Mr. O'Keefe, and the injuries that Mr. O'Keefe incurred were not the result of an interaction with a motor vehicle. So now we go, Your Honor, to the tab 7, which is the invoice. I am going to be very precise and point out some items, hopefully for an efficacious purpose. It says at the top, Arca invoice date, July 12, 2024. Of course, by then the trial is over. Your Honor correctly noted in your preparatory statements about these line items that are in it. We don't run from one word or line in this invoice. But it's important to understand the facts behind this. The last discussion that any member of the defense team recalls having about any compensation at all was back in March, and it wasn't even any discussion about particulars, etc. It was just the defense feeling that they were going to be calling these witnesses. And there was the question of, is there going to be, and I had that as required in there for a reason, because they didn't know. It was just trying to understand this very unorthodox relationship because of the U.S. Attorney's Office, their constraints. The defense position is that there was absolutely no meeting of the minds that Arca was going to be compensated by the defense. It wouldn't have been a surprise if that would have been demanded of the defense, but those were paused. Those discussions were paused. And again, that's the recollection of the defense. And to be clear, Your Honor, as Your Honor knows, I was not a participant in the first trial. I'm not speaking with firsthand knowledge on any of this, but I have conducted as thorough an investigation of these facts and marshaling of them as I think I can possibly do. So here's the punchline, Your Honor, with the invoice. Came out of the blue. It came out of the blue. It gets sent to Mr. Jackson's office in July. I can't reveal attorney-client communications, but I can tell you there's one person that was more shocked than most about the invoice coming in and the amount. So what happened? And this is, Your Honor, objective, these are recollections, information. The defense team called Mr. Adam Deitch at the U.S. Attorney's Office. What is this? Can we pay it? We supposed to pay it? I encourage Your Honor to communicate with the U.S. Attorney's Office about, did this conversation really occur? What was the substance of the conversation? Because, as I understand it, one of the questions of Mr. Deitch was, can we pay this? Are we going to be in violation of some expectation of yours? We want to do this the right thing? Mr. Deitch said, yes, you can pay. Why would the call go into Mr. Deitch if there was a prior agreement that they would be paid for anything? There would be no reason for the call.
Did they pay it?
Yes, that was just the point I was going to get to.
And when was that?
The best of my understanding was very close in time to when it occurred. So I understand the date of this invoice, the date of the invoice is July 12th. And I think I can get you.
So they sent a bill even though there was no contract.
Mr. Jackson's firm, not Mr. Jackson, but a staff member.
Okay.
And I want to be careful of attorney-client communication, so I'm not going to talk about the subject, but communicated to Ms. Reed that this invoice had come in. And I believe that communication was toward the end of July, maybe I'm going to roughly estimate the 24th. And then there was a communication, of course, with Mr. Deitch. And after Mr. Deitch said, yes, it's permissible to pay that, I believe the payment was made very shortly thereafter, maybe within a week.
When was that? Within a week, within that July 24th date?
Get you an exact answer?
I would like that.
Sure. I'm going to attempt to get an exact. If I can't, I think I can get a good approximation.
The defense paid it in the absence of an agreement.
Your Honor, I understand a check was sent to Arca on July 25th.
Thank you.
You're welcome. So there's no doubt the invoice was paid. But the story is not solely about was the invoice paid. The important part of the story about the facts is it came out of the blue. And I don't expect anybody to take my characterization 100%, but that's my full understanding. But the call to repeat to Mr. Deitch is, to me, the corroboration of that very point. And it's an important one. It's an important question, and it's very important question. But it's an important fact point as well that call was made. So in terms of the next tab, which I've been alluding to during
Okay,
my...
so this is the one I said I needed to take a recess to
I was
read
just going to
that.
say the same thing.
All right,
This
so-
is now that point.
All right, why don't we take a 15-minute recess?
Okay, that's odd.
You are muted.
That's weird, man, right? So if I'm understanding him correctly, it sounds like at no point did they have a retention agreement. It sounds like at no point did they retain the experts. There was no agreement. If I understood him correctly, that's what you guys heard, right? There was never an agreement. I mean, obviously, if there were, obviously, that makes sense because then the bill would be a surprise because there's no agreement, right? If there had been an agreement, then their bill wouldn't be a surprise. So there must have never been an agreement. So these witnesses testified with no agreement and then sent a bill. Yes. And we agreed to pay it. Okay. Interesting. As a judge, if I were in this position, I'd really want to drill that down. I'd really want to drill that down as a judge. I'd have several follow-up questions at that point. To be quite honest, at that point, I'd be like, let me make sure I'm understanding this correctly, and then basically ask it back. I'm like, you're telling me at no point you had an agreement, right? And you're telling me that you got a bill, even though there was no agreement, right? And you're telling me that you decided to pay it, right? There wasn't a handshake agreement. There wasn't any agreement. It's just a random bill comes in, and you decide to pay the random bill. Is that what you're telling me? Because that sounds like what you're telling me. Like, okay. All right. And you decide to pay this. And wasn't the bill for like $20,000 or something? Or thereabouts. I forget the exact amount, but wasn't the bill for like something like $20,000? Was it $15,000 or $25,000? It was something in that range. And so, yeah. 23. Okay. I knew it was something vaguely in that range. So you sent $23,000 out the door in the absence of an agreement. I thought you were testifying for us for free. Maybe. I mean, it's not unheard of. We've seen it done before, although it's not, exactly every day, but we have in fact seen experts before in previous trials who have said, yeah, no, I'm doing this pro bono. I am not being paid. Fuck you. So like the idea that like the expert might be testifying for free, it's not completely unheard of, especially if they're testifying relating to things that, the feds paid them for and blah, 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 whatever. But like, okay. I don't know, man. Yeah, I don't know. That's a little bit difficult. Yeah. They're ensuring they show up for the second trial, I guess. Because at that point, the trial was over, right? And so they knew that they were going to need them. So they paid them to keep them happy. Okay, that makes sense. Yeah. But as a judge, I'd want to drill that down. As a judge, I'd want to drill that down. I like, let's make sure that I've got this 100% correct. That what these representations that you're making to me are. It's like, okay, if that's the representation, then fine. But, I want to drill that down. Because that's a very important representation that's being made, to my mind. Yeah. Also, incidentally, by the way, when they were talking earlier about Yannetti not necessarily being on the emails relating to this, that didn't surprise me. Because it is not uncommon when there are multiple lawyers running a case that a witness sort of belongs to one of the lawyers, and that lawyer runs that witness. For the sake of efficiency, for the sake of let's not having to duplicate it on their work. So if I'm working with a team of 4 other lawyers and that's your witness, I may have zero clue what you're doing because I've got my own things to worry about. Don't you mind? Right. So like, I don't need to know everything you're doing. That's your witness. You figure it out, right? I've got my own witnesses to figure out. So that didn't strike me as odd. Now, obviously, that isn't necessarily the case. Sometimes attorneys will share it. So it's not like a hard and fast rule, but it's not odd. Jackson was smart. He prefaced it with the time of the report and said, we did pay. Yeah. Will the defense call Wolf to back up the story? I don't see any reason to. I wouldn't do it as a judge. Like, I wouldn't do it initially. Like, I do depend on the representations being made by the attorneys. So, you know, if I had these questions, I'd be like, if this is the representation you're making me, I'm asking you a question flat out. You know, I'm going to expect you to tell me the truth. So, you know, and your credibility is everything, right? If I don't believe you, I'm not necessarily sure I'm calling another witness in any event, right? So I'm not sure that if I'm the judge in this scenario, then I'm calling the witness I'm calling the witness in any event. Either I believe you or I don't. And it's like, and if you wanted to bring a witness in on your own initiative to bolster your own case, you could have done that. But I don't think I'm going to go out of the way as a judge to call in a witness. It's like, no, this is your presentation. You're in charge. You're a big boy. You can handle it. With the lawyer saying he doesn't want to divulge privileged information regarding discussions about paying. Yeah, it might have just been paying them to keep them around for trial too. Yeah, that sounds promising. Yeah. So Arca is a private company, of course. Arca is a private company. The feds hired Arca to do some things relating to their own investigation. The feds basically, in so many words, let it be known to both the defense and the prosecution, hey, by the way, we've got these experts who can opine about this case. If either side's interested, you know, and you'd like to talk to these experts, we want to let you know they're available. So Arca was being paid by the feds to do whatever it is Arca was doing for the feds. Which then goes to like, what is the defense paying for? Presumably the thing the defense is paying for in their $23,000 bill is literally the time they spent on the stand and travel time and expenses. Is presumably what the $23,000 is for. But yeah. The feds would not have paid for the court day for Karen. Absolutely true. Correct. The feds would not have paid for that court day. Correct. Yeah. So I'm not saying that like I'm not saying that it would have been improper for them to bill for the time. It is weird though that there's no agreement. There's no signed agreement. So it's not unreasonable for an expert to be paid. It is a little weird for the expert to testify in the absence of an agreement. I want an agreement. You know, if I'm the expert, I want to make sure I'm getting paid. You know, so I want an agreement about what I'm going to get paid. I don't want to be left out on a lurch. So, but apparently we're doing this on a professional understanding or something, or some sort of zeitgeist understanding or something. Why were the feds looking into this? They were presumably looking into it to determine whether or not there was official corruption by anybody. And that was part of whatever it is they were trying to do and trying to determine that. I mean, obviously, well, not necessarily obviously, but it would be helpful to the feds in trying to determine whether there was corruption to try to figure out whether or not what was the real story with Karen Reed. And so the idea of them hiring their own experts to try to figure that out is part of trying to investigate whether there's corruption, you know, makes sense. So presumably that's what the feds were doing, because I'm not sure what else they'd be doing. So it was the public corruption unit, I believe, at the DOJ. I believe we do know that. So, you know, yeah, probably. Can I analyze OPM directives given by Trump restructuring senior executive service? Maybe at a different time. Maybe at a different time. So I find the answers personally satisfactory. I find the answers satisfactory. It's like, yeah, we didn't lie. We didn't misrepresent. We had no agreement. We didn't think we were paying them. We didn't misrepresent to anybody. So I find his answers to be satisfactory. I'm not sure the judge is necessarily buying this story, but I find the answers to be satisfactory. And also, like, incidentally and not for nothing, even if it were true, it's a little small. I mean, this is more of a taste thing, but it's a little small for such a severe sanction as the kind we're looking to tee up, right? It feels like even if it were true, like, let's go to the wall and disqualify the experts seems like one hell of a sanction for, that. I mean, I've seen, much more blatant things, unfortunately, that are not sanctioned. So perhaps I'm a little jaded because I've definitely seen much more egregious things that are not sanctioned. So it feels a little small for perhaps this level of outrage. But okay. Maybe Judge Bev just runs a particularly tight ship. Let's go with that. All right. In what way do you find it unsatisfactory, Snoopy Boobs? Do you find it unsatisfactory simply because you don't believe it, what he's saying? Or do you find it unsatisfactory because even if what he's saying is true, you find it unsatisfactory for some other reason? So what is the nature of your unsatisfaction? I'd be interested. Perhaps the defense should ask for sanctions against prosecutors for tampering with mirrored video footage. True. If you don't find him credible, then I mean, fair enough. But if you're saying you're not satisfied because even if you find him credible, it's not satisfactory, I'd be interested why. There's a hot mic. They're not saying anything. There's no one in the courtroom. I just have the audio in the background so I can hear when they come in. You're not missing anything. You're missing the glory that is fan. I'm sorry to deprive you of the glory that is fan. I know you guys like the OnlyFans content, but there is the glory that is fan. The fan feels a little small for the room too. What does the transcript say about compensation? I mean, they read the relevant parts. So, like, yeah, the voir dire disclosed that, in fact, pedestrians are harder to see at night. We did get out that critical scientific testimony. Pedestrians are a little harder to see at night, probably more vehicle accidents, all things being considered, because it's a little harder to see the pedestrian at night. Yeah, that sounds pretty plausible. But yes, we did get that down in voir dire. We got that disclosed. So, it doesn't feel like the state has been put out. You don't believe him? Fair enough, Snoopy Boobs. If you don't believe him, that's fair enough. I mean, credibility is a question for the trier of fact. So if you simply don't believe his representations, then, fair enough. This is incidentally why I'd want to drill down as a judge and make sure that he's saying exactly what I think he's saying. This is why I'd want to drill it down more. But, fair enough. Yeah, if you're being compensated is a perfectly normal question. Yeah, no doubt. Especially for an expert witness. Are you being compensated? Yeah, 100%. That's a normal question. You'd be almost an idiot not to ask the question. Unless the answer is nothing, and then probably don't want to bring that out. But if they're being paid anything, you want to mention that. Yeah. There are 3 lights with the fans. There are 3 lights. There are 3 lights. Yes, so we've got a light fan gangbang going on right now. Lol. On this OnlyFans content. And they're doing it in full public view too, with people watching. It's voyeurism. Smoke alarm is also in there for the ride. Unclear whether or not AC vents is participating or merely watching. I think the AC vent is merely in the corner watching. I think that's what's happening there. Clearly the blinds can't see anything. Cute. Very good. I like that. +1 channel point for the joke. Fire alarm is saying that's so hot. Preach. Thank you, by the way, for the 587 of you currently tuning in. Do really appreciate your being here. If you wouldn't mind, please hitting the like button. It really helps with the algorithm and discovery and stuff. I do appreciate it. Thank you for joining me as we try to dissect the finer points of what is going on in this case. Your participation here is meaningful and appreciated. I love you. You guys are better than other chats because you're here. Also, I put my watch on a red NATO, which I thought was cool. I took a picture of it and posted it on my channel. But the watch has a little red accent there. See on the face, it's got that little red accent there. So I put it on a red NATO. So I'd bring out the accent. Pog. I love this watch. I love this watch so very much. It is the GWM 5610U G-Shock. It may be one of the best watches ever made. It does everything so very well. Yeah. 100 or 150 bucks, depending on the day. Sometimes you can get it for $100. I think it's 150 right now on Amazon, but sometimes you can get it for 100. For 100 bucks, it's a steal. Radio controlled, so it's automatic. It's always the perfect time. It's always dead on accurate. Solar powered. You never have to change the battery for like 15 years. You don't have to change the battery for 15 years. It's got like 5 time zones, 4 alarms, stopwatch, timer. It's got a backlight. You can read it in the dark. 200 meters water resistance, shock-proof case. So great. The Citizen EcoDrive is cool. The EcoDrive technology is very good. I do like the Citizen EcoDrive. Yeah, their solar technology tends to be better than Seiko's, at least in terms of being hidden. Citizen is better about hiding their solar than Citizen is, or apologize, than Casio is. So Citizen's EcoDrive is very cool. Yeah. They also make some GPS watches too, which is pretty cool because then it will automatically adjust the time depending on where you are in the world, which is pretty neat. So if you fly a lot or something, that's pretty cool. You land and it just automatically readjusts itself based on where you are. It's pretty neat. I mean, it takes all of 30 seconds to just change the time zone on my watch, but why even spend the 30 seconds, right? Citizen also makes the most accurate watch in the world. The most natively accurate watch in the world. Their caliber 0100 is a special cut quartz that oscillates at something like 2 million times a second, as opposed to the standard 32,000. So the watch is accurate plus or minus 1 second a year. It's pretty good. So Citizen has the most accurate watch in the world. Hard to do much better than that. So also change time for time zones. You can do that. And daylight savings, yeah, it changes for daylight savings. So this automatically changes for daylight savings. And obviously you can change time zones, no problem. You just go in there and change it. So, but this watch doesn't know where you are. It doesn't have GPS, so it's not that smart, but it's pretty smart. The economy is bad. I could see a CEO trying to generate revenues in a dry spell by saying, what work can we send out invoices for? Maybe. What's the GPS one I refer to? No particular one that I was referring to. There's just a couple models that have GPS built-in receivers. Worked for that guy who got millions from Google. It sure did. Yeah. Sent out invoices to Google and kept getting paid till they figured it out. Yeah. Breitling has a cool feature, a panic button that broadcasts on the aircraft emergency frequency. Yeah, I'm not even sure if that works anymore. I'd have to double check. But I think the FCC reallocated those frequencies. So I'm not even sure the Breitling emergency watch works anymore, but I'd have to double check. But yeah, Breitling made that emergency watch that had a transceiver in it that could signal a plane. That's pretty cool. Judge is in fact taking a long time, I know. That's all right. We got time to kill. We can talk about things. We can talk about the case. We can talk about stuff, whatever. Just trying to have some fun and talk, have some fun together. She's probably calling the U.S. attorney. Maybe she is. She's on hold. What am I cooking again? I just cook from time to time as, the mood strikes me. Do I think we'll get a ruling from the bench? Probably not. That's just not her style. Plus, if she's going to disqualify, that's something she really needs to really put in writing, because she needs to justify it. So if she's going to disqualify, she needs to write it out, and it's going to take some time.
Court is back in session.
May I proceed back to the podium, Your Honor?
Please.
Would you like to remain seated?
You can
Thank
go
you.
back.
May I continue, Your Honor?
Please.
Thank you. So, Your Honor, to blend and quickly summarize what we've gone through I'm using the table of contents of the notebook. We've spoken about the March 20 and March 22nd email from Mr. Wolf to Mr. Jackson. We've talked about June 10th and statements of counsel. We've talked about comments of Your Honor. June 18th, we've talked about briefly the voir dire of Dr. Wolf and the opportunities the parties had there. We talked about the June 22nd and June 23rd's emails from Dr. Wolf to Mr. Jackson and the proximity of those emails to the restart of the trial on the 24th. The 24th is the trial transcript of Dr. Wolf. July 12th, the date of the invoice. As Your Honor well knows, we got you when that invoice was paid. And now, with all of that, what I am going to do, Your Honor, hopefully productively, with no speculation.
Okay, so you don't have to tell me what you're going to do. Just go ahead and do it.
So I will just go ahead and do it, Your Honor. Now to the transcript. And as I go through, I start on page 53.
Okay?
Line 19. And this is Attorney Brennan. Your Honor, my purpose is not to deprive the defense of an expert. I'm going to stop there. That statement is I will carry forward about the Commonwealth's statement that they're not seeking to deprive the defendant of Arca as a witness was made 5 times. I counted them, and we'll go through each one and number them. Or deprive the defense of an Arca expert in this case. Very important, because from my perspective, what was put in the firing line on February 18th was the Arca experts, albeit indirectly.
Yep.
So now we go
You and I both read this the same way.
It's going to be
We both read we both read Arca's in jeopardy.
because the words matter.
Yeah.
Line 5, and this is again is Attorney Brennan. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other, and that expert witness that they don't know about and can't ask about. I'm going to stop there. That they don't know about? Really? Don't know about the Arca experts? February 12th report? A voir dire? Knowing the purpose of the voir dire was we wanted to have these witnesses testify. And then the next statement, and can't ask about? Really? Can't ask about? Voir dire, the opportunity. Next statement, that there's some bias or favoritism that the expert might have towards one side for whatever reason. I don't know what's meant by favoritism, but having worked with experts almost every week, you call an expert to testify. I don't know if I would call it bias, but I don't think it's a stretch to say that if an expert's going to come in and give opinions helpful to your client, that expert is biased. But this expert was not engendered by the defense. It was engendered by the U.S. Attorney's Office in their federal investigation. Next, on line 12. So that if that information is not disclosed, really? It was on February 12th of 2025. Now, I'm going to get to this because, and this is not speculation, this is fact, the entire buildup of February 18th was on the false foundation that the Commonwealth had gotten all the information that they were going to talk about until Your Honor's break. from the federal government and not the defense, which was
Preach it.
completely false.
Preach it.
So
Preach
this
it.
buildup is all in.
And what was the date again that the defense provided it? The Friday night before our hearing?
How
was
can we
it?
be surprised by, because we got it from the
I have to
defense.
think out loud here. I'm going to answer it. I think it was February 12th.
It's a pretty big detail,
that
man.
It was provided of 2025, but it's important to state why that date. Please recall, Your Honor, that the Commonwealth had not yet issued its certificate of compliance with discovery. And I know I don't need to tell Your Honor the rest, you know it better than I do, about counsel's obligation to turn over discovery, et cetera, et cetera. So I don't know if the Commonwealth on the 18th genuinely didn't know that it came from the defense as opposed to the Commonwealth. But what's very, very clear are the statements that I'm going to go through that were all built upon the foundation that they learned about this all from the federal government and that the defense had not turned over anything, which is completely false.
Okay.
So let's go through each word because it gets really important. When there are claims made that the defense has not turned over something and there are words used like ambush and duping, it's important to understand and get behind those verbs as to what the facts are.
Yeah, let's go. Do it.
So the next. So if the information is not disclosed, then it's not only an impediment, it creates a position where there's an unfair examination. Really? Voir dire occurred? It's not the Arca witnesses that I have the issue with. That's number 2 of 5. The Commonwealth is not saying we have an issue with Arca. And why do I keep repeating this? Because my conclusion is going to be Arca should be unscathed. Arca should be available to the defense. And I'm going to get to more of that in a moment. So it says it's not the Arca witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. Those words, I don't have. The Commonwealth had for 5 days the very discovery that was being discussed that the Commonwealth didn't have. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. I agree with that. I agree completely with that. And we complied on the 12th. And it's for this trial that matters, Your Honor. Your Honor has commented before that this is a new trial. This is a second trial. I've tried unsuccessfully sometimes to talk about the baseline with the Daubert issues, and Your Honor has rightly commented, well, Mr. Alessi, this is a new trial. Point taken. Now, I wasn't at the last trial, but I've read the transcripts. That's an important point, Your Honor. Mr. Brennan has said before that he, earlier in these pretrial proceedings, that he hadn't had a chance to watch, he hadn't had a chance. And believe me, I can empathize with Attorney Brennan on that. It's a lot to digest. He and I are both coming into this second trial new. So I appreciated the comments he had made before. But his comment here is I've read the transcripts, and I'm going to assume that for the very important topics he was talking about, he had read the transcripts. But again, that would be something that only Attorney Brennan would know. But it's an important point to point out. That was the representation. But I've read the transcripts. And then he goes on, and on page 55, he repeats what we went through about June 10th and what counsel for the defense had said. So I'm not going to cover that. He's just reading what I took head on before the break. And so we then turn to the continuation of the buildup, which is at the bottom of page 55. Attorney Brennan. Now, I have some familiarity with the federal government. Seemed to me, based on my limited experience, there was much more to the story. And the story is about interactions with the defense counsel. That's what was talked about above. So I called the federal government. There's no statement here, there's much more to the story, and I've got the discovery that the defense provided that told the complete story. So there was, and I'll tell you my impression from what is stated here, is that counsel made these representations, but the Commonwealth couldn't evaluate them because they didn't have information, so they went to the federal government. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. It's another statement so Arca could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. This is talking about discovery and information about Arca that was already in the possession of the Commonwealth. And it was striking that it was noted it was unresponsive just when I read the materials. I don't know which materials Attorney Brennan is talking about. I'm going to give Attorney Brennan on this one the benefit of the doubt that he's not talking about the discovery materials that we had provided, because I think fairly read in context, that's not what he was referring to, but I don't know what's being referred. It's not the point I want to make. And Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. Got them from the federal government. It's not a statement that he got them from the defense, which is a fact. And then we got new materials, but a qualifier, just some. But these materials were the very reason why the defense should not be able to call witnesses without giving full discovery. We had given full discovery. We had given it. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but some Arca, the witnesses themselves, and recent requests for. So he's saying, this is what I got from the feds. And what do I discover when I got this information from the feds, when he really got it from the defense? There's email correspondence between the defense, but not only the defense and the federal government, but the Arca witnesses. And then he goes on. But if we look back earlier in the relationship, what we see back in March 22nd, 2024 is that there are conversations between the defense, Attorney Jackson and Daniel Wolf, who's one of these Arca witnesses. And then he goes on and he reads the email. But the clear import of the point here is that the Commonwealth is saying right here that this is when I discovered these emails. This is how I got them, not from the defense, but the federal government. And we know now that that's incorrect. Then we proceed down to page 57. The Commonwealth, as I understand it, was not aware of any promise, rewards, or inducements, or payment. They relied on a reciprocal discovery order of this court for that information. That's a misdirection. That's a misdirection. There was no promise, rewards, or inducements or payments before all of those documents that the Commonwealth is referring to here. That didn't come until the invoice came in July.
There you go, baby.
It wasn't even a promise. It was pursuant to the conversation of Assistant U.S. Attorney Deutsch that, yeah, you guys got to pay it, and it's okay to pay it. So next, on page 57, line 11, he reads, response, hi, Alan. Subsequent to our conversation on Wednesday, this is, I think he's reading from the March 22nd, but one of the disquieting aspects of this February 18th discussion is it's not chronological, doesn't have dates. So it's kind of hard to follow, but it certainly gave the impression, clearly, not the impression, it was stated that these came from the government, and I'm going to get to it when Your Honor was asking very apt questions about dates. But this is a very interesting paragraph. Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked me, Are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward? Your Honor, I am going to please ask you to turn back to tab 1 of my notebook, because this was a purported quote of the March 22nd email. That's really not close to what the email says. It's not totally incorrect, but here's what I'm going to do, Your Honor. I'm going to assume that the court reporter's transcription was not accurate and that Mr. Brennan accurately, because I'm going to give Attorney Brennan the benefit of the doubt, because I can tell you that I've had my statements in court not completely correctly transcribed by a court reporter. And unfortunately, sometimes it's been on some key things. I don't think this is key at all, but I just note it. But it says, Mr. Brennan goes on, now it's the opinion that troubles me. It's relationship, and the Commonwealth should have an even playing field. That's number 4 of the time he's not having any trouble with the Arca experts. Saturday, June 22nd, Daniel Wolf wrote, Alan, I spent some time this morning putting together a brief outline of my qualifications, blah, blah, and this is just a repeat of what we have already heard. Here now comes the important points. Page 58, line 2. Now, this isn't information provided by the defense in reciprocal discovery. Oh my. This isn't information. She's talking about all these emails. This isn't information provided by defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TURI requests, and an insistence, the best I can, to get as much information as I can. It's incorrect statement number 2, and it's an important one. Down below, unfortunately, it gets even more incorrect. Defendant provided an outline of questions and answers for the direct examination. Please put this in context, Your Honor. The Commonwealth appears to be believing that they got the information from the federal government, not the defendant. So they've got the outline, and they're now accusing the defense of having essentially drafted the outline. Defendant provided an outline of the question and answers for direct examination. That's not a fact, but if that were true, that would be very bad. So
what I'm going to do, I had no idea it's this late. So it's 1 o'clock. We're going to break for lunch. We'll start back up at 2.
Okay, Your Honor.
Right. Do you think, I have no idea how much longer you're going to be, Mr. Alessi. Do you have an idea, and I'm not rushing you, do you have an idea, because we do have the other motions. If we can't get to them today, we'll spend those 2 days next week with them.
I'm going to answer your question. I think I can conclude in 45 minutes because I have to get to the law, the 3.3a. I have to.
I'm not rushing you. I just wanted a time frame.
That's my best answer, and I will say this, Your Honor. I share your interest. I'm presenting some of these motions, and I have a strong desire not to be back here for that. So I share the goal, believe me.
Okay, so we'll see everybody at 2 o'clock.
You are muted.
Well, so far I find his answers perfectly satisfactory. I find his answers totally satisfactory. It's like, yeah, basically, there was no agreement. There was no agreement to pay. We were surprised by the bill, which obviously came after the trial. So, we can't disclose something that doesn't exist. So there's that. And these emails that are going back and forth relating to prep as to the witnesses, like, it feels like just normal prep to me. It feels like standard prep about, things that they're going to cover. So it doesn't seem shocking or surprising to me in any way. There was apparently that, like, they weren't supposed to talk about the substance of something at some point, but obviously once they're on trial, they'd be talking about the substance of it. So it doesn't make any sense. Like, obviously once they're testifying, they're talking as to substance, because otherwise, why are they there? So the idea that there was prep, I don't think, if the testimony itself doesn't violate the rule, I can't see how the prep violates the rule. Perhaps it was just not to talk about the substance of the federal investigation. Perhaps that was the more specific thing, because that would make sense. Not to talk about the substance of what the federal government was doing, as opposed to the substance of the underlying data or information would make more sense. So, yeah, I'm personally satisfied. I don't see any problems here. This seems perfectly appropriate and perfectly reasonable, and the answers satisfactorily address the question. And even as to like things about surprise, it's like, first of all, you weren't surprised, because as the prosecutor said last week, if we'd only known that more pedestrian accidents happened at night, but that testimony was elicited at the first, it was already elicited at the voir dire, so you did know. And second of all, you know now, and so you can't be surprised about it with relation to this new trial, because it's a totally new trial. And so I find his answers to be completely satisfactory. I don't see anything untoward here. I don't see the problem. So I'm satiated. I'm satiated. You get a big bill and you don't email. Well, again, like, as we were sort of saying, right, we want these experts for the second trial. So, right, because we know we have to, so we know that they're good experts, and we know we want them for the second trial. So if they send me a bill for the first trial, even though I wasn't expecting to pay it, as long as it's anything reasonable based on, prevailing rates, right? As long as it's anything reasonable, I'm probably going to pay the bill so that I have them available to testify at the second trial. Because if I don't pay the bill, I think they're going to be somewhat disinclined to testify at the second trial. So that sounds like a bad problem. So, yeah, I mean, I'd certainly consider it. I'd certainly consider it strongly. Yeah, about that. Jackson lied to her. What was the lie? Yeah, what was the lie? Jackson didn't lie. What was the lie? He said he explained it. He said what was the lie? So the state lied all
New
about
donation
this.
from Lil Reaver.
The state certainly has not necessarily been completely forthcoming. Thank you, by the way, Lily Raver, for the super chat, for the donation via Ko-fi. We do appreciate those donations. You think they didn't disclose a verbal agreement? There was no verbal agreement. According to what he just said, there was no agreement. So they can't disclose what doesn't exist. There was no agreement. Okay. Outside of court, Jackson said they didn't pay them. When did he say that? Because they didn't get the bill until June, right? So at the time Jackson said it, was that a lie? Was it true when he said it? It doesn't fully matter what's said outside of court too. That's also fair. It doesn't fully matter what's said outside of court. It's honesty to the tribunal, not necessarily honesty to the general public at large. Yeah. The court works in facts, not speculation. Prove there's a verbal agreement. Exactly. Yeah, there's no evidence. There's no evidence of a verbal agreement. He said he complied with all discovery, then a week later provide emails to the Commonwealth. In relation to what? And when did he say he complied with all discovery? See, the timing here is important, right? Because like you're saying he said he complied with all discovery, then a week later sent something to the Commonwealth. Okay. In response to what? In response in how and in exactly what was said. And also, by the way, the emails themselves are not discoverable because they're attorney work product. So if I said to you, I've complied with all discovery, and then said also, by the way, here's some emails that for some reason I can't even begin to fathom, I'm sending you, even though they're attorney work product, I didn't lie. Because they were not discovery, because they're not discoverable. So, no, that's not a lie either. You want to try again? Yeah, the timing matters, the words matter. Also, if I said I complied with all discovery and there was a change of the request or change in the requirement, and then I provided you new things, that's also not a lie. Right? If I said I complied with all discovery and then those requirements changed and then I provide you new discovery, I didn't lie the first time. So also that, right? It's like, what are we talking about? Yeah. So I don't see a lie. I don't see a lie by Jackson. So based on the representations that are being made in court right now, that doesn't seem like it. So it sounds okay to me. I still to this day do not understand why the defense turned over those emails. That continues to blow my mind. I can only assume there's some court order, but even then I would be like, I'd strongly consider be like, how about no? Because that's work product. And it's like, you want me to turn over my work product? How about go to hell? So to this day, the fact that the defense disclosed those emails continues to boggle me. But, okay, fair enough. Yeah, you can claw those emails in my cold, dead hands. Yeah. You can claw those emails out my cold, dead hands. Oh, man. If AJ gets removed, can you sue Brennan for lying? No. No, he has no cause here. Yeah, why turn over the emails? They're work product. Yeah. Let me show you. And then the emails, by the way, are complete nothing burgers. So maybe that's why they turn them over, because there's like no reason not to. But even still, like on principle, right? Even still on principle. It's like, I'm not going to give you my emails, even though they're completely ordinary and completely, dear expert witness, will you testify for me? I would like it if you testify, XOXO. Dear expert witness, thank you for saying you'll testify with me. I'd like to go over some of the testimony. Perhaps we could work together on it, XOXO. Dear expert witness, thank you for sending some of the things you said. I have some suggestions. Perhaps we could make some changes here that would be a little bit better, XOXO. Right? It's like, okay, tell me a different story. Right? Tell me a different story. Oh Lord, these are the most banal, basic emails of all time. Right? These are the most basic, boring, stupid, ordinary emails ever. Dear expert witness, thank you so much for testifying. You were great on the stand. XOXO. Dear expert witness, I seem to have gotten a surprise bill. Here's some money. XOXO. Oh, man. That's good times. Anything else? By the way, incidentally, I'm going to have to redirect you over to Melanie for the afternoon stream because I have an appointment at 2. So they're coming back at the top of the hour, right? They're coming back at 1. I could only stream with you for like 20 minutes. And then I have to go. So I probably will just send you over to Melanie instead as soon as we're done talking, because it doesn't really, Miss Mandy Reacts just redirected her viewers to me. That's hilarious. Hello, Miss Mandy Reacts viewers. We're about to redirect you. But I do appreciate it. But yeah, I have an appointment at 2 o'clock my time, and it's going to take me about a half hour to get there. So I have to leave in about an hour from now. And so we could have about 20 minutes of stream time, and that's about it. You'll take my 20 minutes of stream time? Okay. We can hang out till then if there's things to discuss. I think Bev would have a very difficult time justifying excluding these experts based on this record. It's a very severe sanction. I mean, it's an abuse of discretion analysis, to be fair. Okay. The judge gets a lot of discretion on witnesses, and she gets a lot of discretion on terms of sanctions for fucking around. And in my humble opinion, not enough judges are breaking out the whacking stick. We've talked about this before. There have been too many judges, in my humble opinion, who are afraid of the whacking stick. But the whacking stick is your friend. The whacking stick is how we get obedience. You do what I want, or I break out the stick, and it will hurt. And you do what I want, or it will hurt some more. So I don't necessarily oppose the judge using the whacking stick. That being the case, however, the whacking stick has to be used in proportion to the offenses. And also, of course, in proportion to any prior offenses, kind of like sentencing a criminal for that matter. How do you determine how long to sentence a criminal for? Well, you sentence a criminal based on how bad is this thing, and also how bad have they been in the past? Those are the two things you sentence a criminal for. So much like that, that's also how you discipline people in a courtroom. How bad is this thing, and how bad have you been in the past? So if it's particularly egregious, you can skip steps. But but I don't think this is egregious. I'm not even sure there's a violation in the first place. So I'm having a tough time finding the violation. And even if there was one, it seems to be relatively small in scope. Right? It seems to be a very small thing in scope compared to the sanction, which is a fairly severe sanction of how about your witness doesn't get to testify. How about that? That's a pretty severe sanction. So although an abuse of discretion analysis is difficult, under these circumstances, I think the judge would be difficult. It would be difficult to justify excluding the witness under this record. That seems really difficult. Things being less than ideal or things being less than perfect does not necessarily mean we go to the wall. She can remove AJ if she wants to. I actually don't know the finer points of that, incidentally, by the way, on that as a matter of law. That's a really interesting question. She has a lot of discretion in choosing to grant the pro hoc vice. I'm not necessarily sure what her discretion is or that it's the same on removing pro hoc vice. It has never come up. It's never come up. So I don't know. Yeah. I don't know if the judge can just remove a pro hoc vice as easily as they can easy as they can grant it in the first place. I don't know. That would turn on some Massachusetts specific law. So, although, yeah. So I don't know the finer points of that. Baldwin only got out because he's rich and famous? Maybe. The sanction was a lot. But, it wasn't completely unreasonable. I don't know necessarily as the judge that I would have done that, but you know, yeah. I really thought she wants to remove Jackson. It feels, I mean, the lawyer that was arguing for the defense agrees with my read, right? Because he even said as much when they came back from that first break. He's like, yeah, basically what this is teeing up is the removal of Arca. So defense lawyer reads it the same way I do. They're trying to tee up the removal of Arca. Like, yep, that's basically what's happening. There's also a case to be made, of course, that the prosecutor, when they were raising this issue to the judge, was, if not lying, misleading in a severely material way. So there's a case to be made for turning around and sanctioning the prosecution for wasting my time. Or more the point, wasting the defense's time. So like an appropriate sanction would be basically pay for their legal fees for the day, right? Because this is your bullshit. So an appropriate sanction to the prosecutor might be pay for their legal fees for the day. Write them a check. I'd think about it. Yeah, Bev should probably whack Hank around for this shit because he was saying like the defense didn't do this and the defense didn't do that. And you got me all hot and bothered, right? You got me all hot and bothered, and now I have to punish somebody, right? You can't tease me in the morning and walk away. Somebody's getting punished. So who's convenient? Any new developments in the FBI? No, not really. I mean, they seem to have ended their investigation satisfactorily. Aunt Bev, of course, was denying a lot of other motions. She denied the defense's request for additional discovery for the metadata, basically saying that what they got was already sufficient because it was a process they agreed to. I'm partially sympathetic. I know Melanie disagrees with me on this issue, but I think I agree with the judge on that one because the issue was when they copied the data, it didn't come along with the metadata. But the idea that there would be metadata to copy or to preserve should have been something that would have been obvious, right? If I'm coming to you and be like, I want this file, I should know that there's metadata. So if what I'm interested in is the metadata, then I should ask for it. And I don't think they can reasonably argue that they were surprised somehow that metadata exists. It's like, well, metadata usually exists for data. It's kind of hard to have data without metadata. I mean, it's probably possible, but it's kind of difficult, you know? So if they agreed to a process that was basically, you know, just drag the file onto the thumb drive or whatever, if that was the process they agreed to, and now they're like, but we also want metadata, then I'm kind of sympathetic to the judge on saying, but this is the process you agreed to, and it's not really fair to ask them to do discovery twice, right? It's like you already have this data. You have the opportunity to get the metadata. The fact you don't is on you. So I'm partially sympathetic to that posture because it's like, well, you know, you can't just keep coming back and asking piece by piece. You know, that's not really fair either. Yeah. If the data was withheld in the first trial, there's magically on a server, there's metadata on that server. Yeah, so I was a little unclear exactly what they were seeking metadata in relation to. Maybe that was part of the confusion. So if it was metadata with respect to the data that they knew existed, then fine. But if it's metadata with respect to, if it's metadata they didn't know existed, because it was like there was metadata somewhere else, then I'd be more sympathetic to it. So I suppose it depends on exactly what was happening there. Why isn't Jackson arguing this himself? He's in LA right now. He said that last week when they were scheduling it, he had a prior engagement in LA and couldn't get back in time. It's a new trial though, yes? Yeah. But I believe this discovery that we're referring to happened as a result of this new trial. I think the agreement she's referring to is an agreement with respect to this new data, or yeah, with respect to new trial. So I don't think the fact it's a new trial changes that part. Jackson is there, is he? Oh, I thought he was going to be absent. Maybe he is not arguing it because he didn't necessarily think he was going to be back in time. And so they wanted someone else to prep it, which makes total sense, right? It doesn't really make sense for two people to prep it. And if Jackson was concerned that he wasn't going to be able to make it back, then one of the other attorneys would prep it. And so they would argue it, because that makes logical sense, right? If I'm concerned I can't be there, I'm going to have someone else do it. And then like, they're the ones that are most well prepped. So they're the ones that are able to argue it. So that makes sense. I'm cute. That's nice. Thank you, Amber Ann. I appreciate that. I'll take cute. Cute is good. It probably is also better coming from a lessee, to be honest. In the same way, you don't want a lawyer representing themselves. So all things considered, it's probably better coming from a lessee. Dial it back, Amber. No, cute is fine. You don't have to dial back cute. Cute is fine. Direct you to Melanie? No, you can. Why don't you just go there? Why don't you just go to that stream if that's what you want to do? No one's stopping you. The metadata on the hard drive to see what happened there 3 years. If it sat there, the metadata would clear the police for wrongdoing. Yeah, it might do. It's a compliment. I know it's a compliment. I'm well aware it's a compliment. Did anything I say or do imply that I didn't understand it was a compliment? I'm confused. I'm confused. The beard is good luck. Yeah, the beard does seem to be a popular thing. No. Chat is mad. That's okay. You don't have to worry about chat being mad at you. You just have to worry about me being mad at you. Lol. But cute is fine. Smile more? Well, I smile when the moment occurs to me. I smile when I'm happier. But I appreciate that. I appreciate that, smiling. Smiling is always a good thing to do. What else? When I'm really happy, I dance it sometimes. Could I replay what Bev said? When? She just basically said, I'm going to break, and how long are you going to take? Let the front go a bit longer and sculpt it down. At the moment, I've just been shaving it even. I've just been cutting it down even. I've been using the 9mm attachment, just cutting it even. I think it looks pretty good at the moment. Is court on recess? The court is very much on recess, yes. We're just killing time for a half hour. What she said when she was upset? Would her treating Alessi, an outsider of first trial, a possible litmus test to see if the judge is holding grudges? Could be. What's my favorite song? That's a good question. Probably something by Nirvana. The one I sing at karaoke is Dennis Leary's "I'm an Asshole." So that's my go-to karaoke song. I'm just a regular. Yeah, The Man Who Sold the World. MTV Unplugged with Nirvana might be the best album ever. Like, I love that album. I love that performance. MTV Unplugged in New York, so good. So good. Yeah, The Man Who Sold the, yeah, anything from that album is a good pick, to be quite honest. I'm just a regular Joe with a regular job. What's the diploma over my left shoulder? This is not, strictly speaking, a diploma. This is my license to practice at the U.S. Supreme Court. That is my license. So that I can be like, I'm cool. I'm Kurt Mueller, licensed attorney. There's my, can we see your license? Yes, you can. There it is. Yeah, that's why that's there. I'm your average white suburbanite slob. I like football and porno, books about war. Average house with a nice hardwood floor. Wife, my job, my kids, my car. Feet on the table and a Cuban cigar. That's not enough to keep a man like me interested. Oh no, no way. No, I gotta go out and have fun. Someone else's expense. Oh yeah. I drive really slow in the ultra fast lane while people behind me are going insane. I'm an asshole. So yo, asshole, the world's biggest asshole. Do I have it in wallet size? Actually, no. Ironically enough, I don't. Yeah, ironically enough, I don't have it in wallet size, which I think is hilarious. You know, the Texas bar gave me the big one, and they gave me a wallet size one, and the Virginia bar gave me a big one and the wallet size one, but the Supreme Court did not give me a wallet size one. That is just a weird thing. And also what's interesting to me, at least, is that the Supreme Court doesn't have bar numbers, which I also just think is odd. I mean, it's like they don't do bar numbers at the Supreme Court. They don't believe in it. So it's like, what's your bar number? I don't have one. Yeah. So they're weird. My Texas bar number is 24-133-133. My Virginia one is 74567, I think. No, that doesn't sound right. What is my Virginia bar number? 74 something. Lol. If I had to choose ascot, bolo, bow tie, or necktie, well, the traditional necktie, of course. If you go practice law at the Supreme Court, do you have to bring the picture with you? No, you just give them your name. I've actually not practiced there before, but I've been in the bar line. So when you go to the U.S. Supreme Court and you want to watch oral arguments, there's a public line and there's a bar line. So I've gone to the bar line before, and they're like, name, and I'm like, Kurt Mueller, and they're like, cool. They look it up on their computer, and that seems to satiate them. So I don't know. They do what they're going to do. What do you want? And also the Federal Circuit didn't give me a bar number. When I got my Federal Circuit license, they didn't give me a bar number. So maybe it's just true that the federal courts just don't believe in bar numbers. I don't know. Maybe that's just not a federal court thing. At least the two federal courts I'm in didn't give me a bar number. I really should join the Fifth Circuit, though. I should fill out the paperwork and do that. What does it take to get into the Fifth Circuit? I can Google while I'm waiting. Let's see. Fifth Circuit Court of Appeals admission. Okay, what do I have to do to get admitted? All right, let's see. Attorneys applying for the Fifth Circuit for the first time must apply via PACER. Okay. Complete the application oath. Obtain a certificate of good standing from a federal court or bar to which you're a member. Okay. A certificate of good standing is not required if you're initially admitted to a bar within 30 days. Log into PACER and register to admit. A certificate completing your admission will be sent to you by U.S. mail. That feels anticlimactic, man. That feels anticlimactic. All I have to do is get a certificate of good standing from the Texas bar and upload it with the oath, the PACER, and they'll send me it back in the mail in 6 to 8 weeks. That feels anticlimactic, man. And I have to pay him $250. Okay. Rainy like the weather gives 499 says, I think AJ's not speaking because they believe Conan is not inclined to actually hear anything he says. And Donna gives 49.99. Okay. So all I need is $250 and I can do it electronically and submit it via PACER. This is too funny. Do I need a sponsoring attorney? Oh no, there's maintenance. I literally, so stupid. For continuing local procedures, for continuing, okay. Are these general instructions? All right, federal bar information. Please provide additional bar information. Okay, fine. Provide information on the attorney sponsoring admission. Do I need a sponsor? It's unclear. Do I need a sponsor or don't I? It doesn't look like I do, but they have a space to request one. Oh, no, I do. Okay. As required by federal rule of procedure, please have a current member of our bar support this position below. Okay, I need a member of the Fifth Circuit to sign off on this. Anyone happen to know anyone who's a member of the Fifth Circuit Court of Appeals? That'd be helpful. Thanks. Need a sponsor. That's lame. At Supreme Court, I needed 2 sponsors, I guess. Yeah, well. I didn't need a sponsor for either Virginia or Texas, though. So that was interesting. I think some states also require a sponsor. I think Tennessee might require a sponsor, but neither Virginia nor Texas required a sponsor. Sponsor sounds like I'm a member of AA, though, right? Hi, my name is Kurt. I'm an attorney. Hi, Kurt. I've been clean for about 5 seconds. The temptation to be an attorney is too real. Can chat sponsor me? No, sadly, no. No, not so much for chat. Well, unless a member of chat happens to be a member of the Fifth Circuit, then yes. Otherwise, not so much. I know who I could ask. I know a law firm I can ask. Yeah, I know a law firm I can ask. And I could also ask Attorney Tom. He might know somebody who could refer me. I'll ask Attorney Tom. Yeah, I'm hooked on reading judgments at the Supreme Court. It's been 3 days since my last hit. Have I seen the new Supreme Court decision on Glossop? Ooh, no, I have not seen the decision on Glossop. That's exciting. Let's do a little emergency Supreme Court decision time. Emergency Supreme Court decision time. Let's do emergency Supreme Court time while we're waiting for the decision. Ooh, they granted him a new trial. Ooh. Cool. Let's see. Let's go. Okay, where is the decision? Okay, Glossop. Okay, argument, opinion. Great. All right, let's read this real fast and see what's going on. This is cool stuff. We covered this case, incidentally, in oral arguments, so this is a case we were following. I don't remember what I said about it off the top of my head, to be honest, but that's okay. All right. In 1997, let me see if I can make this a little bit bigger. Yeah, that'll work. I'll just, there we go. There we go. All right. Glossop versus Oklahoma. In 1997, Justin Sneed beat Barry Van Treese to death with a baseball bat at an Oklahoma hotel owned by Van Treese and managed by petitioner Glossop. Oh yeah, I remember this. This is like the hotel person that was convicted basically on one person's say-so, and that person was like completely non-credible. I remember. Yeah. I remember, yeah. It's just one person's say-so. How about the death penalty? Yeah, okay. By the way, please don't beat people to death with baseball bats. It's not good. Don't do that. Glossop initially made inconsistent statements to the police about Sneed's role in the murder, but he ultimately told the police that Sneed admitted to killing Van Treese. Sneed later claimed that Glossop had asked him to do the murder because, among other things, Glossop had wanted to steal Van Treese's money. Yeah, wasn't he like an assistant manager or something? And he did it in order to get a promotion or something at this rinky-dink hotel? Something like that. The jury convicted Glossop and sentenced him to death. The Oklahoma Court of Criminal Appeals overturned the conviction because defense had been ineffective in challenging Sneed's testimony, and the remainder of the evidence only weakly corroborated Sneed's account. At the retrial, Sneed, and by the way, I mean, just pick the most dick dastardly name ever. I mean, do you really have to make it this obvious you're the bad guy? Your name is Sneed. Your name is Sneed, man. At the retrial, Sneed provided inconsistent testimony on the potential motives of Glossop's murder. Sneed also denied that he had been prescribed lithium or seen a psychiatrist. After defense established through state's medical examiner that Van Treese had been attacked with a knife as well as a bat, Sneed testified that he repeatedly tried to stab Van Treese in the chest with a pocket knife. But Sneed had previously denied stabbing Van Treese, both when being questioned by the police as well as Glossop's first trial. Yeah, this is the most credible witness ever in all time, right? I had nothing to do with the stabbing, but there were stab marks. I totally did the stabbing, though. This is our witness. This is the guy we're believing when we're sentencing someone to death. Holy shit. Okay, but this is the guy we're going to believe. We're going to believe the lying, convicted murderer with the inconsistent stories. Yeah, that sounds good. Okay. Anyways, pressing on, Glossop moved for mistrial based on prosecution's failure to notify defense about Sneed's change in testimony, which the trial court denied after the prosecution disclaimed any knowledge about the change. Glossop was again convicted and sentenced to death, and a closely divided court of appeals affirmed, holding that circumstantial evidence suggested Glossop had mismanaged the hotel, combined with Glossop's concession that he'd been dishonest in his initial statements after the murder, sufficiently corroborates Sneed's testimony that he killed Van Treese at Glossop's direction. That is some weak ass circumstantial evidence, man, for the murder. Okay, we think you did the murder. We've got this guy who says you did the murder. You were a murder for hire. What else we got? You didn't really manage the hotel very well. Wait, how is I didn't manage the hotel very well corroborating evidence for I did a murder? Maybe I'm not the best hotel manager. How's that corroborating for I did the murder? Not quite sure about that one, but okay. And also, when he talked to the police, he may not necessarily been 100% completely honest. Don't talk to the police. Glossop subsequently filed several unsuccessful habeas petitions. Concerns over the integrity of the conviction led to a bipartisan group of the Oklahoma legislature to a commission to independently investigate by a law firm, Reed Smith. Okay, you know it's bad. You know it's bad when the legislature is getting involved and wants to do their own investigation into this proceeding. That you know things are not something has gone wrong somewhere. The legislature wants to investigate. What the hell, right? So the legislature's now gotten involved. Okay, that's exciting. So they hire this law firm, Reed Smith. Can you take another look? In June 2022, Reed Smith, the law firm, and presumably the guy as well, reported grave doubts about Glossop's conviction, citing factors such as the prosecution's deliberate destruction of key evidence and false portrayal of Sneed as a nonviolent puppet. I mean, he seems a little violent with the stabbing and all. He's a nonviolent stabber, though. Okay. Sure, let's go with that. He's a nonviolent stabber. The state then disclosed 7 boxes of previous withheld documents. It's going super well over here in Oklahoma. Super duper well. We have an additional 7 boxes of discovery to give you after the second trial. Here's an additional 7 boxes of discovery. It's going super duper well here in Oklahoma. Okay, the state then disclosed it had 7 boxes of documents we hadn't disclosed before, including letters suggesting Sneed had considered recanting. Well, that sounds like, potentially exonerating evidence, wow. They have documentation that shows that Sneed was considering maybe recanting his testimony. That sounds like that might be some interesting impeachment testimony evidence. Maybe we should have the interesting impeachment evidence. Maybe that would be good. No, you're not entitled to the interesting impeachment evidence. You're not entitled to that. Oh, okay. All right. So we have a letter suggesting Sneed had been recanting and a note from the prosecutor, Connie Smothersman, to Sneed's lawyer, noting they should get to Sneed to discuss his problematic testimony about the knife found in Van Treese's room. Glossop then filed for post-conviction relief based on this evidence and evidence revealed by Reed Smith. Glossop also argued that during his second trial, Smotherman had interfered with Sneed's testimony about the knife in violation of the rule of sequestration, which prohibits witnesses from hearing another's testimony. Oklahoma waived any procedural defenses to Glossop's claim and asked the Oklahoma court to deny the claim on the merit. The court denied the claim as procedurally barred, even though the state's like, we don't care about the procedural bar. But the court's like, we care, though. It's like, okay, that's interesting. So the state's attorney's like, we don't care about the procedural bar. This is cool. And then the Court of Appeals is like, but the procedural bar, though. All right, fine. The state then discovered additional documents, even more additional documents. The discovery of new and exciting documents continues anew. Our discovery of new and exciting documents continues. After the second retrial, after the state legislature got involved, after this independent law firm had been engaged, we still have new exciting documents. What are the new exciting documents? Let me tell you more about it. Okay, the state then discovered additional new exciting documents revealing that Sneed had been diagnosed with bipolar disorder and prescribed lithium, contradicting his trial testimony. Well, that's interesting. That's interesting. The witness was bipolar. The witness was on lithium. Maybe this might be information we should tell the defense. Maybe the defense might like to know that information. I haven't been diagnosed with any condition. I'm not on lithium. As it turns out, yeah, you were. All those things. Oh, okay. That sounds like something we could have impeached him with. I wish we had known that. Okay. The Attorney General determined that Smotherman, the prosecutor, had knowingly elicited false testimony from Snead and failed to correct it, violating law. In other words, the prosecutor suborned perjury. Yeah, great. It's going super well over here. So among other things, the prosecutor violated this case called Napoo versus Illinois, which held that prosecutors have a constitutional obligation to correct false testimony. Yeah, kind of, sort of. Yeah. Glossop then filed a petition for post-conviction relief, which the Attorney General supported, conceding multiple errors that warrant new trial. Again, you know things are not going well in the great state of Oklahoma when the Attorney General of Oklahoma says this trial was fucked up. You know things are not going great. The Attorney General themselves has gone involved and be like, yeah, this trial was whacked though. That's how well it's going over in Oklahoma. It's going super well. Great. All right, so the Attorney General's like, this trial's fucked up. However, the Court of Appeals denied the unopposed petition without a hearing. This is great. This is super wonderful, right? The Attorney General themselves has deigned to be like, you know what? We're really kind of concerned. We're really a little concerned over here. Really think maybe this is a problem. And the Court of Appeals is like, nope. Also, we don't need a hearing. We're just going to dismiss this completely out of hand. We know the prosecutor waived the procedural issue. We know the Attorney General themselves has waived the procedural issue, but we're not about that life. We're not about that life. We're going to dismiss this petition out of hand. How exciting. The Court of Appeals denied the unopposed petition without a hearing. So even though there's no opposition, he still loses, holding that Glossop's claims are procedurally barred under Oklahoma's Post-Convictions Procedure Act, and further, the state's concession was not based in law or fact because it did not create a Napoo error. So that concession that says this is a new error, no, it's not. No, it's not. This concession, I don't know why the Attorney General is saying this. Why is the Attorney General saying these completely random things? Why is the Attorney General saying some crazy things? You know, they've gone all soft sit. The Attorney General themselves has gone all soft sit, and they're making weird and strange ramblings in court about how there was procedural error and how they were deprived of fundamental rights and how this is a violation of the Constitution. These strange ramblings have no basis in law or fact. From the Attorney General. Cool. So I hope you enjoy your execution, says the Court of Appeals. Which incidentally, by the way, of course, once again, in this context is the Supreme Court of Oklahoma, because Oklahoma bifurcates its Supreme Court because they want to be special. So when they say Oklahoma, it's actually not the Oklahoma Court of Appeals. I keep abbreviating Oklahoma Court of Appeals because that's what I'm used to reading. And it's actually not the Oklahoma Court of Appeals. It's the OCCA. It's the Oklahoma Court of Criminal Appeals, which is the Supreme Court of Oklahoma. Because Oklahoma's like, we'd like to have two Supreme Courts. Texas, incidentally, also has two Supreme Courts for reasons that I continue not to understand. So when they say Oklahoma Court of Criminal Appeals, what they're saying is the Oklahoma Supreme Court, because they have two Supreme Courts and they like it that way. So the Supreme Court of the state's like, yeah, we don't really care. That's all fine by us. Okay. So here's what the Supreme Court of the United States would like to say in, reference to all that. Please tell me this is ancient. This decision came out today. Please tell me it's ancient. No, it's happening right now. Today. This is today. This is brand new. This came out about 3 hours ago. So it's ancient in so much as it happened 3 hours ago. That's how ancient it is. Great. Moving on. The court has jurisdiction to review the judgment. The independent and adequate state doctrine precludes the court from considering a federal question if the state court decision rests on independent and adequate state law ground. The application of it was not such a ground because the decision to apply it depended on an antecedent rejection of the Attorney General's confession of NAPU error, which is, of course, based on federal law. So, if this was procedural default under state law, the Supreme Court says we can't do anything about it, which is completely correct. And I said that before, right? The state is the ultimate judge of its state law. I was saying this the other day in regards to the Karen Reed stream. And the Supreme Court of the United States just said the exact same thing, right? That's what they're talking about, right? So if this was an adequate ground of state law, the Supreme Court can't do anything about it. The United States can't do anything about it. But, it's not an independent and adequate state ground because you relied on a U.S. Supreme Court case called NAPU. And amazingly enough, we get to interpret that. So we have some federal law questions for you, right? The OCCA held the confession could not overcome the limitations of state law because it lacked a basis in fact, specifically finding no NAPU error. Oklahoma precedent confirms that, the highest court of Oklahoma normally rejects an attorney general's confession of error only after finding it unsupported by law. Okay. By making the application of the state law contingent on the determination the Attorney General's confession of federal constitutional error was baseless, the state highest court made the procedural bar dependent on the antecedent ruling of federal law. To the extent that the reasoning on this point is insufficiently clear from the face of the opinion, the court presumes reliance on federal law under a different law. So, just in case you're going to be like, we didn't rely on federal law, we're saying you did though. In case it was unclear. Yeah, you relied on federal law. And so, we have a thought about this as it relates to the federal law. Cool. So let's talk a little bit more about the federal law now, because, we can't really talk about Oklahoma law, but what we can talk about is the federal law. So let's talk about that. The prosecution violated its constitutional obligation to correct the false testimony. Under NAPU, a conviction obtained through knowing use of false evidence violates the 14th Amendment due process clause. Amazingly enough, the U.S. Supreme Court said it's bad for the prosecutor to use suborned perjury testimony. I get you would have never thought that, right? You would never thought the Supreme Court would have to say, you know what is wrong? Suborning perjury to convict people. But apparently the U.S. Supreme Court had to say that at some point because, apparently that was a question in someone's mind. Okay, suborning perjury if you're the state is really, really bad. Don't do that. Cool. To establish a NAPU violation, defendant must show the prosecution knowingly solicited or allow the false testimony to go uncorrected. If the violation is established, a new trial is warranted if the false testimony could, in any reasonable light, have affected the jury's judgment, meaning ordinarily the prosecution must establish harmless error beyond a reasonable doubt. So harmless error, but beyond a reasonable doubt. So harmless error with teeth. Here, the Oklahoma Attorney General joins Glossop in asserting a NAPU error, conceding the Snead testimony about the lithium prescription was false, and the prosecution knowingly failed to correct it. The record supports the confession of error. So unlike the Oklahoma Supreme Court who said, we can't find it in the record, the U.S. Supreme Court's like, we can. We can find it in the record. Not sure what you were talking about on that one. Evidence shows that Snead was prescribed lithium to treat bipolar, not after asking for cold medicine as he claimed at trial. Do people use lithium to treat a cold? I was unaware that lithium was used to treat a cold. Is lithium a cold remedy? But apparently that's what he said. I was prescribed lithium because I was a little under the weather. And so it was to help fight the bug. Okay. I didn't know lithium was used for that. Apparently lithium is a cold medicine now. That's new. Interesting information. Okay. The evidence likewise established the prosecution knew Snead's testimony was false. The prosecution almost certainly had access to Snead's medical file through the competency examination, one would imagine. And Smotherman's notes, who, by the way, we've already found suborned perjury, shows that she had a pre-trial conversation with Snead at which he mentioned lithium and Dr. Trumpet. So in addition to like everything else, I vaguely remember this from when we covered it before. There was like literally a note written by the prosecution, like in the prosecutor's handwriting, that basically said, Dr. Snead, lithium. So that goes a long way to showing the prosecutor knew. We have it in the prosecutor's handwriting in the file. That seems like some reasonable evidence that maybe the prosecutor knew. You know, that the Dr. Snead, how do we know she knew about Dr. Snead and lithium? She literally wrote the words Dr. Snead and lithium in her own hand. That might be a clue. The straightforward inference is that Smotherman was aware at trial before Snead had received his lithium prescription from Dr. Trumka, a psychiatrist and sole medical professional at the Oklahoma County Jail authorized to prescribe lithium. Because Snead's testimony was the only direct evidence of Glossop's guilt, the jury's assessment of Snead's credibility is material and necessarily determinative. Yeah, this might have been helpful information for the jury. I'm not really sure why the jury was believing this guy in any event, to be quite honest, given everything else, but holy shit. But yes, maybe the jury would have liked to know this guy was on drugs and, you know, bipolar and a liar. And maybe that would have been helpful information to the jury as they're trying to assess this witness's credibility. Cool. The false testimony also bore on Glossop's guilt because evidence of Snead's bipolar disorder, which could trigger impulsive violence when combined with drug use, would have contradicted the prosecution's portrayal of Snead as harmless without his influence. Well, that sounds like a thing that might be a problem. He's a bipolar guy with a drug problem. I wonder if that might potentially have some sort of violent consequences. I wonder if the combination of those factors might potentially increase the probability that Snead might be a little violent sometimes with the stabbies. The bipolar drug user. This is our witness. This is what we've got. Cool. Great. I mean, at least by comparison, Jen McCabe looks like the most reliable witness of all time. I mean, so we'll give that to Jen McCabe as we're trying to relate it to this story. Jen McCabe, to the best of our knowledge, is not a bipolar drug user. So, you know, she may not be the least credible witness of all time. We can do one better, at least. In any event, hence, there is a reasonable likelihood that correcting Snead's testimony would have affected the judgment of the jury. Seems like something that could have happened. Additionally, prosecutorial misconduct, such as violating the rule of sequestration, destroying evidence, and withholding witness statements, further undermines the confidence in the verdict. That is the most understated statement I've ever read in my life. That is peak understatement. You guys think that I do understatement as sarcasm sometimes, right? You guys know that sometimes I'll do understatement as sarcasm. You guys think that I know how to do understated sarcasm. I got nothing. I got nothing on the Supreme Court. I am a mere amateur compared to these levels of understated sarcasm. Additional prosecutorial misconduct, such as violating the rule of sequestration, destroying evidence, and withholding witness statements, further undermines the confidence in the verdict. You think? Consequently, the prosecution's failure to correct Snead's false testimony entitles Glossop to a new trial under NAPU. Maybe just don't prosecute him, though. The evidence seems a little thin. Maybe don't prosecute the guy for the conspiracy murder thing. The evidence is a little thin. Maybe not do that though. The highest court of Oklahoma's contrary holding rests on a mistaken interpretation of NAPU. The Oklahoma Court of Criminal Appeals, which of course is the Supreme Court for the purposes of this discussion, held that there was no violation because the defense was aware or should have been aware that Snead was taking lithium. But Snead's false testimony concerned the reasons for his prescription, not the mere fact he had taken lithium. Apparently, the defense being aware that he was taking lithium for his cold should have been sufficient disclosure. I'm not really feeling the sufficiency, man. Moreover, the due process clause imposes the duty to correct false testimony on the state, not the defense. Facts. The highest court of Oklahoma holding that Snead was likely in denial of his mental health disorders is beside the point. What matters is that the testimony was false and the prosecutor knowingly allowed it to stand. Additional arguments in support of the Supreme Court of Oklahoma's position are unpersuasive. NAPU does not require that the false testimony itself must have directly affected the trial outcome. NAPU requires assessing whether the prosecution's failure to correct the testimony could have contributed to the verdict under a beyond a reasonable doubt standard. Also unpersuasive are arguments based on extra record materials and insufficient time spent interviewing the prosecutor. Because the Attorney General's confession of error is supported by ample evidence, the court declines to remand the case for further evidentiary proceedings. When the court has jurisdiction, a new trial is the appropriate remedy. So, like, you can try again if you really, really want to. Sotomayor delivers an opinion of the court in which Roberts, Kagan, Kavanaugh, Jackson, and Barrett join. Barrett files an apparent concurring. Thomas files a dissent in which Alito joins. Gorsuch takes no part. A 6-2 opinion. Do I want to read Justice Thomas's dissent? I kind of do. I kind of want to read Justice Thomas's dissent. Let's see what Justice Thomas had to say about this. Okay. Okay, where is it? Hold on. I have to scroll for a while to find it. I'm scrolling. Still scrolling. Why does the Supreme Court have to write so many words, lol? Was that the swear effect button? No, that was just the audio from the court. I was checking to see whether the audio, and right now it's just doing the tone. So that was not a swear button. That was just a tone from the broadcast. All right, Justice Thomas, who Alito joins and Barrett joins us to some parts of this. All right, cool. Richard Glossop, a convicted murderer twice sentenced to death by Oklahoma jurors, challenges the denial of his fifth application for state post-conviction relief. I mean, it might be his fifth, but things don't seem to have necessarily been going well for Richard. He has some questions. Although Glossop won the support of Oklahoma's new Attorney General, he failed to persuade either body with authority to grant him relief. The Oklahoma Court of Criminal Appeals denied Glossop's application as both procedurally deficient and non-meritorious, and Oklahoma's Pardon and Parole Board denied clemency. Because this court lacks the power to override these denials, that should have marked the end of the road for Glossop. I suppose quite literally in this case, because, of course, it's a death penalty case. So, end of the road in a very literal sense in this case. Instead, the court stretches the law at every turn to rule in his favor. At the threshold, it concocts federal jurisdiction by misreading the decision below. On the merits, it finds due process violation based on patently immaterial testimony about a witness's medical condition. Okay. And for that remedy, it orders a new trial in violation of black letter law. Okay. Interesting. Yeah, I think I'd like to become an appellate lawyer. I think I'd like to try to find a position where I could, do civil appeals in particular on the federal level. I think would be cool. So if I find the right position, I think I'm going to go back to full-time work in the law. All right, blah, 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 blah. He's just going through procedural history at this point. And so I'm blah, blah, blahing over the procedural history. All right, and we discussed that. Oh, here's the note. Here's the actual note. He put a copy of it in the record. Oh, Lord. On lithium, ? Dr. Trumpet, ? Yeah, there's a copy of the handwritten notes. All right. Let's see. Blah, blah, blah. Okay. All right. As an initial matter, we lack jurisdiction to review this case. The court from time to time on its foundation, here's the principle: not review judgments of state court that rest on adequate and independent state grounds. That's absolutely 100% true. Because this court has no power to review a state law determination that's sufficient to support the judgment, resolution of any independent federal ground for decision could not affect the judgment and would therefore be advisory. If it rests completely on state level grounds, then yes. Thus, on direct review of a state court judgment, the presence of an adequate and independent state ground imposes a jurisdictional limitation. Correct. He's correct as to that much. Because if it gets down to the state level rule, only the state Supreme Court can change that. Decision rests on such ground, majority concludes otherwise only by grossly mischaracterizing the state court's analysis. Okay. I don't know. Here they held that procedurally barred the application twice because he failed to meet the diligence or actual innocence requirements. Actual innocence is really hard to prove, incidentally, because you basically have to prove beyond a reasonable doubt that you are actually innocent. And that's incredibly hard. It's insanely hard, particularly in light of a conviction, to be quite honest. It explained that because Glossop had been aware of the conviction in lithium, with reasonable diligence, the violation could have been previously presented. They could not establish that but for the alleged violation, no reasonable fact finder would have convicted him. Really? Correcting Snead's testimony simply would have furnished the defense with additional impeachment that did not directly contradict the state's basic theory. And that would not cause a reasonable fact finder to change their mind. But evidence of factual innocence must be more than that which tends to discredit or impeach a witness. Well, as to actual innocence, I tend to agree, but that's not what we're talking about right now. Okay, I'm tired of reading this decision. It makes me hurt.
Is that what's best for the court?
Yes.
Okay. So the March 22nd email, I've dubbed the pause email.
Yes.
And because of obvious reasons, and it's got the word pause in there. And the pause is a very, very important concept because the pause is the stopping of communications before really things even got underway. It was before there was even an agreement, an engagement, et cetera, et cetera. So compare that, please, to the quote, purported quote on page 57. 11, hi, Alan, subsequent to our conversations, and he's quoting purportedly this email. On Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward? Your Honor, there's not one mention of the word pause in that quote. The word pause was left out of that quote. That is the foundation of that email. And it's not merely semantical, it's the cutting off of communications. And it's unfortunate that that pause was not quoted on page 57. Now back to page 60, or excuse me, back to page 58.
Yep.
And this is where I left off. Line 2, now this is information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TURI requests, and in assistance, the best I can to get as much information as I can. Defendant provided an outline of the questions and answers for direct examination. So this is where I left off. That's not correct. It was Dr. Wolf that provided the outline. It's really important when we're talking about a collaboration, et cetera, communications. That's not accurate. And Your Honor, what is important to note, Your Honor asked about when did the defense provide the discovery.
And you told me the 12th, right?
And I want to correct that. I was off by a day. It was February 13th.
Okay.
Because it's important to try, I clearly understand, to be as accurate as we can. I'm the one creating the standard that every word counts, every date counts, so I want to try as my best. I may get some things wrong, but I want to try my best to be accurate. So what I did during the break is I went and asked for the email that sent that request. So it's the email from the defense to the Commonwealth providing the discovery.
Okay.
And the email is dated February 13, 2015 from, and I've got extra copies if the court wants it, if the Commonwealth wants it, from Evelyn Arellano, and she is an employee of the Worksman Jackson firm. And it's important to who it's addressed to. 2, the first name on it is Hank. That's the first name on it. To Hank, Mary Ellen, Adam, and 9 more. Good afternoon. The Dropbox link below contains Arca reciprocal discovery. Please let me know if you experience any issues accessing the files.
Okay. What time of day? Because if it's California time, it might be different than what we have here, but...
It probably will be, but I don't know what time of the day. I'm going to ask the team if they can access what time of the day, because I don't know the answer to that as I stand here.
Okay. All right. Go right ahead.
And so it would suffice it to say that the hearing was on the 18th. So it wasn't like it was a Friday, and then we're back in court on a Monday. My best recollection, the calendar will be the best evidence, is that this was toward the middle of the week, right? But in any event, let's say worst case scenario was dispatched at 9 o'clock at night, California time, which would be midnight Eastern time. And let's just...
If we can, because I'm looking at a calendar.
Absolutely.
If you don't, I thought you may have had it. We can move on.
I think it's approximately 6:30 in the evening. It was received by the Commonwealth.
Thank you.
What the hell just happened?
That's Eastern time, 6:30?
Eastern Standard Time.
Thank you, Ms. McLaughlin.
And Your Honor, it was a Thursday.
I'm sorry.
It was a Thursday.
Okay, thank you.
I'm still alive, so I don't know what the hell happened.
Also, in big bold letters, at least on the printout, the subject is Karen Reed - Arca reciprocal discovery. It's not like it was buried what was being sent. I mean, this was a lot of things, but it's right there, Arca reciprocal discovery.
Was it just these pages that we've been talking about, or was it a lot more discovery?
May I confirm with counsel? I think I know the answer.
It was just the pages, Your Honor.
Okay, thank you.
So it's not like this, Arca is amidst a sea of other topics, right? This is the driving force of the email. And so, Your Honor, the question, and I'm going to keep moving on, but the question becomes, and I'm going to ask it more than once, but hopefully not too much, how is it that the Commonwealth on the 18th understood incorrectly, I think it's undisputed it's incorrect, that they got these materials from the federal government? We don't know the answer to that question, but I respectfully submit it's an important question. Was it an honest mistake? Was it just, as happens sometimes in lawyers working together, there's a lack of communication, there's a miscommunication? Is that the explanation? But I think truth and justice on these topics, since we're
being so exacting and appropriately so, we should have an answer to that question. So we move on to page, so there we have on page 58, we have another incorrect statement. We have two of them right up off the top, and then we continue on to page 59. Your Honor, understandably, says the court. What is the date of that? Mr. Brennan, it's not dated.
When I said it, what was I talking about?
I believe, Your Honor, you were talking about the outline.
Just give me a second. Let me make sure.
And Your Honor, if I may, I want to give you the second, but the basis for that answer is page 58, line 7, where the statement is, and what follows is all about the outline.
Okay.
So Your Honor, appropriately and understandably, says, what's the date of that? Here's the answer Your Honor got. It's not dated. It's not dated. Now, let's please just go back to tab. We're talking about the outline. Let's go back to the outline. And we can pick either one. I'll pick perhaps the most probative one. I'm not going to refer to the tab because Your Honor says you have these. This is the June 23rd email from Daniel Wolf. I'm just pausing to make sure you're... Thank you.
It's what I refer to as a script, right? That's what you're referring to?
That's what Your Honor has referred to it as.
Yeah, so that itself is not, I understand it's with the email, but it's not dated.
Well, Your Honor, I was going to get to that, but there's context for that.
Okay, go ahead.
The context, you're correct. The outline itself is not dated. However, the attachment, keep in mind, we produce these materials.
Okay.
So we deal in e-discovery all the time. And when you look at the attachments, everybody relies upon the attachment line, especially if it's a Word document. So it's wolf_direct.docx. So you know this email has an attachment. We fortunately have a file named direct. Your Honor has referred to it as a script. There is no other document that was produced that comes anywhere near close to this being the direct. So I don't believe there's any reasonable basis other than the other email on the quals that came the day before, 2 days before, the day before June 22nd, which has the same attachment wolfquals.dcx.
Can I ask you a question just
Yes.
because I don't understand? So what I have separately is the script and then something saying qualifying the expert. Is this all one document?
No, Your Honor.
All right,
And
so
I appreciate the question.
What is the date of the, so you're saying what I refer to as the script was sent on the 23rd?
That is correct, Your Honor.
What was the other one?
The other one was sent the day before on June 22nd.
Okay.
I'm just going to give the name that the email has. I think it's wolf_quals document. Okay? So there's two emails. One's just the quals. The other, respectfully, Your Honor, I know what you're calling it. I'm just going to call it what it says. Sure. The title is direct.
Okay,
so
guys.
It doesn't matter which one.
Okay, guys, as I sort of said before, I have to run. I have an appointment that I need to get to, and I need to drive there, and I need to make sure I make it on time. So I'm going to go ahead and end the stream, but I had a lot of fun with you today, and I hope you had fun with me. I'm going to go ahead and redirect you over to Melanie Little. Go have fun in her chat. I will just kindly remind you that they're extremely pro Karen Reed over there. So, be civil and accordingly, don't cause any trouble. So they're Karen Reed through and through. I have a more nuanced approach. I'm not sure that they qualify as nuanced. That's no disrespect. That's just how their chat rolls. So they're very pro Karen Reed over there, and I'll redirect you over there and, be nice. Until later, I've been on Civil Law. Hope you all have a great one. Till later, my friends. Bye for now. Bye-bye.